And as most of you already know, City's Admin Code 8.3 requires that a schedule for the systematic retention and destruction of records be in place for every department. Records, as defined by Admin Code, is basically any medium of information that's made or received by the department in connection with the transaction of public activities for the content or to protect the legal and financial rights of the city. So the current schedule we have right now for the Sunshine Ordinance Task Force items that's posted on the SF Board of Supervisors website, the Sunshine Ordinance Task Force website, as well as the City Administrator's Index of Records. It was last updated in July 1st, 2001. So so needless to say, it's outdated, it's obsolete, and frankly, it's overly exhaustive. And the application and intent of a records retention schedule is to provide a systematic means and guideline for the retention and destruction of records, which will ensure overall accountability over the information we provide to our public, minimize the necessary overhead and storage costs, and provide operational efficiencies internally within the clerk of the board's office, who administers, who's also the Sunshine Ordinance Task Force Administrator. So with that said, the schedule that we have attached to your agendas are what best reflect the full inventory of records that are in possession by your Sunshine Task Force Administrator. And upon consideration of your recommendations, it's going to be consolidated with the full schedule that the clerk of the board has with all the other divisions as well. And then after that, it's going to move down the approval path to go to the city attorney's office to review any records on the schedule that have legal significance. It's going to go to the controller's office for any records that for records relating to any financial matters. And then also going to be reviewed by the retirement board as to time rolls, time cards, payroll checks, and any related matters of that sort. So. And then lastly, after it goes through the entire final approval path, the schedule is also going to be submitted to the city administrator's office for inclusion into the citywide index of records, which is inclusive of all city departments. So with that said, if you're curious about what's been changed on the current schedule, we did some analysis and we basically cleaned it up to focus on the preservation of the content for the department, reducing any duplication and conflicting durations that we've seen that are on the existing schedule. And then we also provide a lot more clarification actually on the descriptions of the records and expanded them so that they're a lot more meaningful, so that when the public looks for a record and wants to see what inventory of records a specific department has, they can clearly, it's all clearly defined as to what's there. And then I also included references to supporting legislation that supports that retention policy for those particular items. And just as a general disclosure, the schedule serves merely as a guideline for the departments, and any department or staff can elect to retain any record for longer periods as required, and it doesn't absolve any responsibility to maintain records that are relevant to public business. So, but then it does meet the requirements of City Admin Code 8.3 and then provides us a systematic means and guideline for the retention and destruction of records. And with that said, I'd like to open up the floor for any input and feedback that you might have, and we'd love to be receptive to that.
Other member, Hill-Pow.
Thanks. I did have a chance to review the materials. I did not compare the proposed schedule to the current. I'd like an opportunity to do that.
No problem.
I understand that we don't need to act today, but we'd like to do this soon, so there's not another 12 years.
Sure.
I get that.
Yes.
I just wanted to raise a few concerns. There is a category for general correspondence and communications,
right,
for which you're proposing a 3-year retention period.
Right, which is reflective of
consistent with the other divisions? Okay.
It's consistent with other divisions and consistent with what is on the current schedule that's been approved. Okay. And I'll be glad to have conversations offline as well.
We'll talk about that. It may be, I'm thinking that a slightly longer period may be appropriate. 4 or 5 years. I don't know that it's a big deal.
Okay.
There's no proposed section about appointments of members, and I think that whatever files on member appointments should be permanent records. So if we need to refer back to who served 10 years ago or 15 years ago, we should be able to do that. I assume that we have files, some of which may be duplicated elsewhere within the clerk of the board, some may not, because we, in theory, have an ex officio member appointed by the mayor. That wouldn't be reflected elsewhere. And there was one, things like press releases and other sorts of matters are probably general, so they'd probably fall into that other thing, but they might also warrant a longer retention period. I also wanted to explore a little bit about paper records versus electronic retention, which I know you're in the middle of and dealing with. So those are some of the concerns I had, and I'm happy to meet the next month, and I think that we're pretty close to approving, or I don't know if we're actually approving or if we're making a recommendation to the clerk of the board as part of the approval path, but I understand that.
Right. You would be making a recommendation, and I do have a response to a couple of those items that you addressed, if I may. So as far as communications, the communications 3-year retention, just want to make clear that the proposed correspondence are only for correspondences that don't pertain to a complaint file.
Right.
So anything that's not part of it. And then as far as member files, so we agreed that would fall under the realm of a personnel record, which is permanent, and that information, it can be generated off of PeopleSoft
It's not necessarily those types of records, though. So that's why we need to sit and talk.
So we can definitely have that conversation.
Okay.
And then,
I also wanted to understand better the implications of this change. Are there a group of records that we're now retaining pursuant to the old schedule that would likely be dumped as a result of implementing the new schedule? You don't have to answer that now, but it's something to think about. And are any of those records which might be useful in the future for whatever reason? We should also perhaps think about what records are duplicated elsewhere in the city attorney's office, either with our designated deputy or with the supervisor of records or other kinds of places. And in some cases it makes sense to have duplicate locations, in other cases it doesn't, but so long as somebody has it, right? If the city attorney, for example, is going to make a permanent record of the supervisor of records reports, then maybe we don't need to keep them for so long as we know that they exist somewhere. Anyway, those are some of the things we need to explore, I think.
Right. And the intent of when we created this was for the preservation of the content and not preservation of the medium.
Right.
Right. So
or location, but so on.
Or location.
Right.
So regardless of whether it's in paper format, whether it's in digital format, whether one department has it or another department has it, we wanted to make sure that the content was preserved, regardless of what the retention schedule states. So. And again, I'd be glad to engage in additional discussion with you if you have any specific example, more specific cases, and I'll be glad to kind of walk you guys through just exactly the inventory of records that we do have in our office.
I'm happy to take this on in the next month unless anyone else cares. See everyone jumping.
Member Nee has we have some comments and questions.
Well, just coattailing for a minute or three on that separation or distinction between paper and electronic records. You are probably aware that the Committee on Information Technology and the Department of Technology are involved in a seemingly interminable project to consolidate and upgrade the electronic system, the system for backup storage and retrieval of electronic records. I don't know, do you have any idea on where they are in this, and has the work they've done so far opened up any more capacity, storage capacity or bandwidth? And when they've completed it, what are we looking at? What additional abilities will that give us in terms of backup storage and retrieval?
No, we have approached COIT and requested for digitization resources first of all, and we have been involved in conversations with them. As far as capacity digitally, from what, and again, don't quote me, but what the IT staff have told me is that they've upgraded their servers and they do have additional capacity to retain digital records. We're also in conversation with Coit. Nothing's been confirmed yet, and I mean, I can get back to you on that item. So.
I guess the question I have for the moment is, with are the systems and facilities that are out there now sufficient to accommodate what you're proposing here in this packet today?
As in the retention schedule? Well, I just want to make clear that this is the retention schedule is a guideline and not. As far as how these records are retained, it's still up to the record holder. It's the record holder's responsibility as far as like retaining those documents. But in my opinion, yes. I work closely with the IT staff, and I have full confidence that they're able to retain all these records if they were to be digitized. Now, as far as the physical records, they are managed by a city vendor, which multiple other departments use as well, and we do hold them accountable for anything that they hold for us. So,
Are there any more questions or from the members? At that case, I would like to, so we don't have any real definite answers for this, so I think what we're trying to do is kind of listen, because what we need to do is tell you that, vote on it, and then, which is down the line.
Right.
So this is just kind of like an initial opening to
Right.
the conversation?
Right.
Okay. Wondering if anyone in the public has any comments or questions that they'd like to address to...
Good afternoon, Chair Grant, Patrick Manette Shaw. I'm here on my own time. I do have a question about whether the schedule that's attached to this agenda item is the proposed schedule or the current one.
It's the proposed schedule, correct? It's the new one
proposed.
that he did on October 8th, 2015.
And so the only other observation I would like to make is directed to Member Pilpel, whom I think the retention schedule is identical for both electronic and paper.
Okay,
Thank you.
thank you.
Is there any more?
Members of the task force, Ray Harris, Director, San Francisco Open Government. I myself brought a couple of complaints against the San Francisco Police Department and the Police Commission a few years back for failing to maintain the index of records. The law basically says that the city departments will maintain an index of records to allow members of the public who want to access public records to be able to know exactly what departments have. And you would go to the website or the index of records and you would click on a link and it would take you to a dead end. And it was just a generic list, and in fact it was almost the same generic list on every department. Now certain departments have on their own websites put in some indexes of records so that you can research what they have, but I would like to have you, or ask you to consider throughout this process that if the citizens do not have the ability to research exactly what records and types of documents a department has, it makes it almost impossible to do a meaningful request. And a lot of the problems I think citizens have in the city is that they will pretend, even though they know what you want, that they don't understand what you want. And part of that is the fact that you ask for a specific document. If you have the index of records, you can look and say, I want this specific document, and they have a hard time fighting that. But if there's just this generic list that says records, they go, oh, well, what's the specific name of that record, or who keeps that record, or what department is responsible for that record, or what agency, it really becomes a thing. So again, as you move forward to this, please keep in mind that one of the key things that needs to be available to the public is an index of these records so that they can do research and do meaningful requests for documents. This also saves time and money for the city, because rather than having to make a huge blanket request for thousands of documents, you can pinpoint 2 or 3 documents that you want and ask for them specifically.
Great, thank you. Is there any more public comment on this issue?
I see a 2-minute clock. Is that what applies here?
Yes, for this,
There
yes.
should be 3 minutes, and that's in the Sunshine Ordinance.
It's up to 3 minutes at the call of the chair.
It's not the call of the chair, it's not in the law, it's the person
The
who's
clock going?
speaking
I'm sorry.
choice.
Because this was just, I just offered the opportunity for public comment, so you can start it now. Thank you.
The Sunshine Ordinance clearly states 3 minutes. The suggested schedule, first of all, I hope you do not take action today, because you certainly should have a comparison of old and new, and you do not have the old one here, as we learned from, in part, a previously asked question by a member of the public. Second of all, I certainly think that if it's correct that current records can be destroyed in less than 5 years, if their destruction or other disposition within a shorter length of time will not be detrimental to the city and county or defeat any public purpose, who is to determine that? It's very problematic to me to see that on page 10 of your agenda packet, page 3 of the memorandum, it looks like the Sunshine Ordinance Task Force Administrator and the Clerk of the Board are approving, at least initially, what anything to do with the schedule is. And I'm sorry, but that cuts you out completely, and that's not appropriate. The records retention schedule doesn't look too bad because most of the total retention periods shown are permanent. But I think that for meetings, well, let's start out. Policy until superseded, I think that's very bad, in case anybody wants to refer to, well, what was the old policy, or what do I remember of the old policy, or how does that compare to the old policy? That's number 8. Reports, the Supervisor of Public Records, that's an annual report of what, 12, 20, 30 pages, only 7 years, that's bad. And I think meetings, only 3 years, I think is also problematic with respect to agendas.
Thank you. Is there any more public comment on this issue?
Yes, there is. My name is Jason Grantcars, and I've been before this farce, which I call the Ministry of Sunshine, because just like in George Orwell's time, everything here is not what it seems to be, exactly the exact opposite. When we speak about records and record retentions, it brings up an awful lot of curious questions. I'll be speaking to you guys later today in regard to probably my 4th or 5th request for medical records under the Department of Public Health, and each and every time prior, you guys have said, well, it is a public record. Each and every time the Department of Public Health has said, no, it's not, and we've had to redo this wheel 20 different times, because that's the nature. So my question about records is, do you guys keep any precedents of your prior decisions so that people don't have to go through this reinventing of the wheel each and every time the other side says no? Because nowhere can I find, that these comments were made, or the fact that, yes, I won my orders of determination, because apparently the Department of Public Health continues to state the same tried and true incorrect law interpretation that they've used for the last 10 years, and nothing has come from that. Speaking of record retention also, for example, I have an article here in 2002, speaking about the Sunshine Committee, the ratchet response I got, and how, of course, there was going to be Member Nee who's going to be on a committee to make sure these kind of things didn't happen 10 years ago. It's awfully, awfully discouraging when you guys get up and apparently are the shill for the city. This record retention stuff, what does it mean? What is a record? Are your decisions records that are easily, followable? Or as I've said before, I'm going to file another complaint against the Department of Public Health, and we're going to be through this rigmarole for the 5th or 6th time in the last 10 years, and we're just going to continue with the farce.
Great. Thank you. Is there any more public comment on this issue? If not, public comment is closed. Member Washburn?
I just had a comment regarding what Mr. Hart said. I just wanted to make sure that we remember this important point in a further discussion of this issue of retention, and that's the importance of having an index of records that's meaningful to members of the public. And he made an excellent argument that it's important for the member of the public who is interested in finding something, but ultimately it saves time and money for the city. And I do recall the case that he brought with the police department and was part of working with them to help them get a handle on this. And I'm not sure whether this is something that Mr. Ng could take into account when you're developing the guidelines, or whether we need to work with COIT. I know we had conversations with them about how do we ensure that all of these records are easily searchable and so forth. How can we make finding a record pretty easy? The process transparent and efficient.
So as I mentioned earlier, I mean, we are going to be collaborating with the city administrator's office, who is the holder of the index of records, and they're the ones that coordinate across all the departments. But we are going to be working very closely with them. For example, this format was dictated by the city administrator's office. So we are adhering to their format, and we are categorizing our information accordingly. And we are going to be working very closely with them to ensure that all the Sunshine Awareness Task Force items, and any items that are within the jurisdiction of the clerk of the board, that they are searchable and findable and easily accessible by the public. Because, I mean, I do find that as a primary purpose for the schedule.
Yeah, thank you. It's a very important point that now's the time to really ensure that we do this right.
Absolutely.
Okay, thanks.
So it appears that we still have a lot of work to do with Mr. Ng. So can you come back up here for a second? So I'm wondering if, instead of kind of continuing this till next month, we all take a look at kind of what's been proposed before us and come back next month with suggestions for you. Would you be, is that something that's feasible for the members? I've looked at this, and I do think Ms. Washburn has a point about the actual content that is being retained, that it is important that we have it kind of like worded and can work in conjunction with you.
Sure.
So, yeah, so I think rather than continuing saying we're going to make a vote on this next month, I think there's a little bit more we'd love to maybe propose.
Absolutely. And,
Okay, cool.
I mean, that's the whole intent. I mean, we do want to open up the floor for any feedback that you guys do have and take
Okay.
that into account. So.
Okay. Does that make sense? Do you guys, next month, that maybe if we have some more specific suggestions for you,
Absolutely.
that we could propose those at that time, or do you need to January? Asking the members. Member Oka?
Yes. As I'm listening to this, I forgot to mention during our comments that currently the records that are available are not very user-friendly for people with visual impairments, because the Acrobat reader does not read most of the electronic documents that we get, and I don't know why.
Okay.
Unless all the documents are scanned and not kept in its original form, because the reader does not read scanned
Got it.
documents. So that's not quite fair to people with visual impairments who rely on the reader to get their documents read to them.
Okay. Sure. Okay, if that's the case, I think that is an important point, and we are going to work closely with the city administrator's office. It is their website, the citywide index of records, but we will make every effort to make sure that, to put in our recommendations that this should be ADA accessible. At the very minimum, we will speak with our in-house IT staff so that when it is posted on the Board of Supervisors website, that at the very least that's ADA accessible. So, of course, we can't, we don't have jurisdiction over what another city department, how they administer their website, but we'll make every effort to make that recommendation and put that comment forward.
Great, and then we'll do the same as well. So, okay.
Point of order through the chair to address Member Oka's concern.
You would like to address Member Oka?
Just briefly.
Sure. Can you speak in the microphone now? Thank you.
If the readers, Member Oka, are not picking up the text, it could be because various city departments scan to PDF in different formats.
Yes.
Some of them are scanned as images, as pixels,
Sure.
and others are programmed to scan to what is called searchable PDFs. And I think if the city administrator and the Board of Supervisors would recommend that every document be scanned to searchable format, that may help with the ADA accessible issue.
Yes.
Got it. Okay. Thank you very much for that. So that's a good note. Okay. I don't think there are any more questions. Can I get a motion to table this to offer our recommendations to Mr. Ng for next month's meeting, the December meeting?
Move to continue to next month?
Do I have a second?
Second.
Great. It's been moved and seconded. Second. So if there's no, is there any more public comment about this? I know we just talked about it, but go through point of order.
I just wanted to agree with the previous speaker. The difference between searchable and non-searchable is enormous and does not just affect those with vision problems or any other disability. It affects my ability to be able to find something perhaps that Member Oka said, and if I search for Oka, I can find it really quickly if it's searchable. If it's not, and there's a long document, it may take me a very long time to find that. So that certainly would be a recommendation that I think would be useful to make with respect to all documents that are stored, that they be searchable, and the benefit would fall to everyone, I think.
Thank you. Is there any more public comment on this issue?
This is on the motion to continue.
On the motion to continue this item? And then I have one more last question for you. Sorry.
So one quick point. That awful good government guide issued by the city attorney's office says that backed up documents are analogous to being in a dumpster and they don't have to be searched for. That needs to be addressed in this policy. That if you're discussing records that are backed up, you need to make sure that the city attorney understands they are not sitting in a dumpster and they have to be pulled off of backup tapes.
What do you mean when you're saying backed up items that are just, that were...
The city attorney has taken the position that when public records no longer exist in a file cabinet or on a network drive, but that they do exist on a backup tape sitting in Department of Technology, that would be the former DTIS, that when it's sitting on a backup tape, city departments are not required to produce it because the city attorney claims wrongly that it is analogous to sitting in a dumpster, and they don't have to go dumpster diving. So any kind of backup records that could be affected by this policy that exists on backup tapes needs to be addressed.
Got it.
Thank you.
Thank you. And Mr. Ng, so if we do want to compare, one last thing, if we do want to compare this proposed schedule to what's before? Do we just go back on the,
Yeah, it's available on the Board of Supervisors website, also available on the Sunshine Ordinance Task Force website. So if you go to Board of Supervisors, sfbos.org, and we go under Clerk of the Board,
That's the old
FAQs.
one. Okay.
And it's that's where the master list is.
and then this is the proposed?
Right, and
Okay.
everything that starts with an S is Sunshine Ordinance Task Force items.
Got it.
Well, I have a quick question. So I'm looking at our site, the Sunshine Ordinance, page 5554. Is that what we should be referring to as the record retention and destruction schedule?
It should be. It should be on the Sunshine Ordinance Task Force website as well. I think it's for the SOTF website. It's filtered down to just SOTF items, whereas the comprehensive list of all departments under the Clerk of the Board
everything.
isn't.
And it starts at ad hoc committee and goes all the way to task force procedures. It's
Right.
Because the Sunshine Task Force is kind of unique in a certain way, and some about the records and things of that sort, I mean, we can make recommendations that might differ from what a lot of the other commissions. Are you guys trying to keep everything pretty much?
We would like to keep it consistent because when people do search through the index of records, I mean, we do want, for example, like with communications, we want communications to be consistent across the board as much as we can. That way there's, that there's some type of structure that we're adhering to. I mean, of course, there is flexibility within every department, but and again, my role isn't to tell you guys what to do. It's to advise. But yes, so I mean,
take it into consideration.
Take into consideration that other departments, or a majority of the other units in other departments, may be adhering to different guidelines. So
Okay, perfect.
so there is a norm.
Yeah, I can see. So I was wondering if that was a possibility. We might propose something like that to you, if you could put that into recommendation.
Sure.
And we will include in next month's packet the current and the proposed so that people can see the difference. And if we
Absolutely.
need
Yeah,
to-
I'll include
And if
those.
we need to compare and do marked revision, whatever, we'll figure it out. I'll make some time with Wilson.
As opposed to that.
Yeah, look
Okay.
forward to that conversation.
Thank you.
Thank you so much for coming. Appreciate it. So we have a motion on the floor, and it has been seconded. Second, can I get a roll call vote on this one?
Sure. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Absent.
Absent.
Oh,
He's still not here.
sorry. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Chair Fisher?
Vice Chair?
vice chair today.
Vice Chair
That was
Fisher?
last month. Aye.
Fisher, aye. And Chair Grant?
Aye.
You can go now.
You have 8 ayes. You have a quorum. You have, it passes. Sorry.
Great. Thank you so much. So see you next month. Thank you. Madam Clerk, can you go to the next item on the agenda?
Item number 3, pending complaints and 45-day hearing rule, schedule of complaints.
Okay, so I'd like to open this conversation up. This is about the fact, well, Madam Clerk, can you tell us how many cases we have on complaints we have right now that we need to hear?
Pending, there are 40 complaints in the pipeline.
Okay, thank you. 40. And how many were filed this is November, so in the month of October, there were how many filed? Approximately. 20, like
In the
one
month of
person.
October, approximately 10.
Okay. And then September 10, or just to get an idea?
September more, looks like about 15.
Okay. Okay. So what we're trying to do, Member Washburn asked me to bring this up, and I do recognize that we've got to figure out a way to hear some of these, to hear many more of these cases. I know that we are trying to do this as quickly as we can. So just to give people an idea, I was wondering, because, I tried to change the format so that we hear the complaints first versus how I think it was done before when you listen to the minutes, because I think that is a priority for us, because there's so many complaints, is to try to hear these complaints. So, for example, on January 16th of 2013, we had 7 complaints agendized, and we heard 6 of those, and 1 was given off. Compared to the year before, when there were 13 cases that were put on, complaints that were put up, and only 4 were heard. So when I look at that, I'm trying to get to the point that we can get a majority of those things heard. What concerned me was April 4th, 2012, an example, like we can put a lot of cases there. There was 16 cases that were complaints that were brought before the task force. 9 were heard, but what was more troubling, which was I don't want to waste anyone's time, I don't want to waste the public's time, I don't want to waste our time, is that 5 were tabled. So, and it ended at 11:17, that meeting, so if people waited that long, and I mean, you guys were here to know that more, and 5 of them, they stayed and their cases weren't heard. So I think that is not a good thing. At this rate right now, it's November, December, January, so it's the holidays coming up. If we were to implement like an extra meeting, it would take almost an extra meeting, 1 meeting per week, almost to like hear 5 cases to get us for the new year, because you think 5, 10, 15, 20, it would take us almost that many, it would take us 2 months. Adding an additional meeting per week, per month, do you see what I'm saying? Because you need 5 cases you need that time to get up to speed. Remembering that we, weren't in session because we were not in compliance for a while, that brought a lot of issues there too. So just kind of knowing the facts, I really would love to open it up to you guys to see what kind of suggestions, thoughts, to try to make this a better situation so that we can get up to speed with these complaints in these cases. So I'd love to open it up for Member Powell and then Member Washburn.
I appreciate that this item is before us for discussion. I think it is serious, and it doesn't look like it's getting better. I think we have some options. We can, as you suggest, meet more frequently, twice a month, 3 times a month, every week, until we've dealt with the backlog, assuming that the rate of new cases being filed doesn't change substantially one way or the other. That's an option. That may be something that we need to think about. We could change our procedures so that we meet more frequently in a different way. I have thought for some time that we could consider jurisdiction at one meeting and consider an item on the merits at a subsequent meeting if we find jurisdiction, and that we could apply that question of jurisdiction in a different way than we have to date. I am of the view that essentially a petition for a determination of whether a record is public, a 21E determination, we are required to hear, and an advisory opinion under 12L, so long as the conditions precedent to issuing that opinion are met, we have to do that. The other types of complaints that we hear with regard to the minutes, the other conduct of departments or other actions of various city officers are 67.30 complaints, for which I think we have discretion as to whether or not to hear, and I think we could exercise that discretion to hear some and not hear all of those.
But that doesn't, I mean, those are few and far between, the types of complaints. You know what I mean? That's not going to get us.
Well, I'm just saying that we could establish a higher bar for what we're going to hear. We could have different procedures for complaints that appear on their face to repeat allegations that have been previously heard by the body, or by this exact body as opposed to the body 3 or 4 years ago. Because those happen. So I'm just trying to think through the kinds of things that come in and options that we have to deal with them, so that we're not here once a month till midnight and still not getting the work done. So those are some initial thoughts. I'm happy to chime in later. I want to hear from others.
Yeah, I do think, I will let you talk. I just think that for the bylaws, I think that every member of the public, the way it is right now, they're entitled to file a complaint, even if they filed, it seems to us on face, the same complaint 3 or 4 years ago. Right now, they're entitled to, from my understanding, file a complaint at any time which they wish. So that's
They are, but we could have different procedures for how to handle it.
That's true, but then you're getting Yeah, okay, so I'm listening, I appreciate, yeah.
I'm not saying I'm in favor of it.
Yeah.
I'm just saying that we have options.
Yeah, I understand. Member Washburn? Thank you.
Okay, before I heard what Mr. Pilhill had to say, I was going to say that I don't see any way around not having an additional, I would say an additional meeting each month for a while. I would not be in favor of meeting weekly. That's far too much of a burden on all of us, including our administrator and each one of us. But I think having 2 meetings a month for a while would be very helpful. We have such a backlog. And then Member Pilpel brought up some interesting suggestions. One thing we could think of doing is we at one time had a complaint committee. And this committee, I didn't serve on it, but I was, when I first joined the task force, it was in place. But one thing they did was determine, they would hear from both parties, and they would determine jurisdiction. They would bring their recommendations to us, and we would pretty quickly, more or less rubber stamp what they decided, usually. That might have saved us a little bit of time. That committee could perhaps, in working with the administrator, possibly look at individual complaints where there could be some further mediation, or the matter could be sort of settled and not reach here. But I am firmly opposed to deciding that some matters, should be heard before us and other matters shouldn't be heard before the full task force. I think that's a pretty tough call to make, and I would not at all further our fundamental business of furthering open government in this city. But I think that the complaint committee could be resurrected, and I think it's a standing committee that's not meeting right now, but I think some thought could be given as to how that could serve to help with this backlog. But I personally don't see any way around I think we're going to have to double up meetings for a while. Mm-hmm. And maybe one of those meetings could be the only thing on the agenda other than public comment is our cases to hear. Complaints, right.
Straight complaints.
Yeah, bang, bang,
Nothing
bang.
else on there.
Yeah, yeah.
I could see that. Member Nee.
Yeah, I first of all, I agree on the 2 meeting a month suggestion. We've done it before. Yeah, it's a little bit of extra work for all of us, but we're here to serve the public, and if that's what it takes to get the job done, to do our job, then I would say let's do it. As far as resurrecting the complaint committee, I really don't agree with that. In most cases, deciding jurisdiction takes 2 or 3 minutes, and it's not that much of an additional burden on us. And all the complaint committee does is it kind of adds a layer of procedure that I don't think is necessary. Also, I would still like to see, and this is relevant, I would still like to see this task force establish a technology committee, information technology committee, whatever you want to call it, to work with particularly now with what COIT and the Department of Technology are doing. I think, we need to interface with them. We need to make sure that what they're doing, how they're implementing what they're doing, is going to comply with Sunshine. And particularly given that, we're 2 members short, we still have 2 vacancies, I think it would make more sense to form a technology committee than to bring back the complaint committee.
Okay, thank you. Any more comments from the members? Then in that case, I would like to open it up to public comment.
Thank you, Chair Grant. Patrick Manette-Shaw. I have to heartily disagree with Member Washburn's characterization of Member Pilpel's suggestions as having been interesting. I found them not at all interesting. I'm not sure that changing the procedures to meet differently or to use your discretion which cases you're going to hear and which ones are not are appropriate. I agree with Member Washburn that you should have more meetings, in part because not only does 67.21E say that the SOTF has to decide whether a record is a public record within 45 days. 67.35D, in addition, says that in order to seek enforcement action, when enforcement is not taken by a city or state official, complainants are permitted to go into any court of competent jurisdiction to seek enforcement within 40 days. Chair Grant?
Yeah,
I'm trying to see
we were
that.
reading it. It was 35D
Reading
as
as
in
you're going
Delta.
along.
35D as in dog.
Okay.
Says that 40 days after a complaint is filed, that members of the public have a right to petition a court of competent jurisdiction to seek enforcement. So while you have a 45-day window under 6721E, you only have a 40-day period under 6735D. This may have been unintentional when the ordinance was adopted, but you need to start meeting quickly and start hearing more cases, even if you have to remove everything but complaints from your agendas.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I know when I come here and I yell at you about stuff, it's sometimes hard to differentiate whether I'm yelling at you or whatever, and I think it's a time that I kind of apportion the responsibility. One of the issues related to the 45-day rules is the fact that it has been over a year and a half, I don't even know how long it is, since you've had these 2 vacant seats. The Board of Supervisors has done absolutely nothing meaningful to fill those vacancies. You have 3 holdovers on the task force, which is also a problem. Now, I've said very clearly that Ms. Osbury is much, much better at the job she does and is much more responsive than either of the prior administrators, Mr. Darby and Mr. Rustum. And I compliment her on that, but I sometimes also have the feeling that she's caught between a rock and a hard place, where she is not given the resources she needs to do the job, and as a result, some of these things drag on. It is also an obstructive pattern by the Board of Supervisors and other city agencies. You know, they don't want to hear a complaint. For example, the one we discussed earlier where Mr. Song said, well, we didn't get the documents, therefore, we ought to continue this another month. That was filed in May, on May 1st of this year. They had 6 months to produce the documents. If they choose to wait until the last minute to produce the documents and then want to rely on that to get a delay, I think that's just letting somebody benefit from their own negligence. But I think one of the things that has to be clearly established is part of this responsibility is not on you. It is the Board of Supervisors and the clerk of the board who, for whatever reason, have determined that they are not going to fill these vacancies. They're not going to answer questions as far as when they're planning on doing it. And I tried to go before the Rules Committee, but they do not let you talk about anything unless it's on the agenda, and they're not going to put this on the agenda.
Thank you. Is there any more public comment about this issue? Any suggestions?
Go ahead. Peter Warfield, Executive Director of Library Users Association. Again, 3 minutes is what the Sunshine Ordinance provides, not the 2 you are giving here. The chair says that she wants to put 6 or 7 or has put 6 or 7 items per month, and your administrator says 10 complaints were filed in October and 15 in September. You're falling behind even keeping current with what's currently being filed at that rate. I have been asking you for many, many months to put out front what's your backlog and how are you going to handle it. I'm sorry it's taken this long. I'm glad you're apparently trying to deal with it now. I think that Member Washburn's, there was a suggestion made to have 2 meetings per month. I think you should speed up and have as many meetings as late as necessary to take care of that backlog as soon as possible. And if you're worried about meeting till 11 o'clock, then meet twice a month. Certainly the old subcommittee method, which now you seldom have subcommittee meetings, required members to come twice a month anyway. From unfortunate experience with the complaint committee, which ended up, as Member Nee said, being just another layer, it was worse than that. It was a chance to spank members of the public who had complaints, to tell them, oh, you have to say this, you can say this much, but you can't say that much because now you're getting into the content. And then we started getting into discussions. What is the content versus what is enough information to determine jurisdiction? Member Nee's request for a tech committee, I think, is extremely valuable. The portion of this ordinance that deals with technology has never seriously been taken up, and it's badly needed, and I could certainly give examples if anybody would like even one. Thank you.
Thank you. Is there any more public comment? Mr. Grossman, after Mr. Grossman, is there any more public comment on this issue? Because I want to make sure we get to general public comment then as close to 5 o'clock as possible.
I don't want this charged to my time. Section 6715C of the Sunshine Ordinance. You want me to read it, or you want me to tell you what it says? What it says is, each policy body shall adopt a rule, providing that each person wishing to speak on an item before the body at a regular or special meeting shall be permitted to be heard once for up to 3 minutes. There's no rule here. It's not the call of the chair. For every meeting of this body that I ever attended until this group took over, you got 3 minutes. And I'm talking about 7 years of meetings. So change the clock. We set it to 3.
I'm not going to change it because it is for up to 3 minutes.
You're going to have to do it.
No, I don't have to. So.
Is this, are you proving that you're a chair, or are you proving something else?
Just proving I've
Are you going to charge the time that I just...
This is your time. This is your time. So however you choose to deal with that. In public comment, I will allow 3 minutes on general topics. But for this particular matter, I'm going for up to 3 minutes.
You don't deserve the effort I put in.
Thank you.
Hello, once again, my name is Jason Grant Garza, and having heard this 45-day rule thing and everything else, I'm a bit perplexed because for the last 10 years, me coming here and filing IDRs and asking that the IDRs up for a hearing, they never happen within 45 days. As a matter of fact, I never even get a response till after the 45 days till I've asked, well, why haven't I been responding to? Case in point, according to the administrator in September, there was 15 filed. Well, I filed 2 separate ones, IDRs, in September, and on 9/26 I asked the SOTF for a hearing request, followed up on 10/5, 10/11, 10/18, and 10/25 to the Sunshine Task Force saying, well, excuse me, you haven't even acknowledged receipt of this hearing request. Mind you, yes, I have the paperwork. I also have, evidence from where these little tactics have been used before, where the 45-day thing isn't even scheduled. The hearings are not even scheduled. There was no acknowledgement or receipt of my email requesting the hearing from our competent administrator. This was, like I said, the IDR that I submitted to the Department of Public Health was on 9/21. When it wasn't fulfilled on 9/26, the IDR, I requested a hearing through the administrator. And like I said, followed up on 10/5, 10/11, 10/18, and 10/25. The other one was against the San Francisco Police Department for an IDR. I still have not heard from anyone. Amazing, isn't it? 45 days, and I've not heard from anyone. Let's see, I filed the hearing request on 9/26. It's now 11/6, and I've not even had an acknowledgement of having asked for a hearing from the competent Ministry of Sunshine. Oh, what a wicked web we weave when we intend to deceive.
Thank you. Is there any more public comment on this matter? If not, I would like to go back to the members and see if there's a suggestion, a motion. Knowing that it's November and December, before we make a decision, I want to make sure that we have a quorum. If we do decide to do an additional meeting per month for the next couple of months, think about that, because I don't want to say we're going to do it and then we don't have a quorum and then it doesn't work. For me, I think that an additional meeting would be fine solely with the issue of the complaints on it. So you put nothing else on there in public comment. That would be the only item that I would want to see on there. It is a matter of the room and all that kind of stuff, though. And I would just keep it to one additional meeting per month to be realistic. So with that, Member David?
I'll be out of the country November 13th to the 23rd. So.
Okay.
When do you propose these start?
This is November, so I mean we could start it, which is...
Here's the calendar. I mean, today's the 6th.
Yeah, I want to get your guys' opinions about this. Member Nee?
I believe that the chair could announce, if the city attorney and or the administrator will correct me if I'm incorrect, but I believe the chair could announce tonight that we will have a task force meeting, a special task force meeting on the 20th, which is 2 weeks from tonight.
But the problem is, and Madam Clerk, correct me if I'm wrong, that you have to check about rooms that are available. So it's not that easy. She can't just, like if I can't announce it because there might not be a room available that day. So,
Well, maybe we should just...
I mean, I can send an email.
Maybe we should plan to start in December.
December.
Then. It would be easier on the administrator and everyone else concerned.
So knowing that our, Member Sim, I was going to say, knowing that our meeting's December 4th, that then gets you into Christmas, which is difficult.
I don't think we have to do it on Wednesday.
No.
I was going to suggest looking at all possible days that rooms are available. It might be the way to get into this quickly.
So you know what? Yeah. So why don't we do this starting in December? Because then that way it gives you time to see what rooms are available after our December 4th meeting. But I would request that up to the 20th of December, because then people are going to, for holiday purposes, that week of Christmas, and the week after is New Year's. So you can find a room anytime. Is that cool?
Yeah, I think we should keep November on the agenda if we find a room. I mean, we still have 2 weeks.
But we won't have time to
Announce it.
Yeah, and that's to make sure, and to get the complaints out. The administrator, she can't get that in enough time. That's not allowing her enough time.
2 weeks from now, if
We don't know if we have a room. That's the problem.
I'm doing the if-then, allow my...
But we would have to announce it tonight.
We need 2 weeks' notice to announce it? I only need 72
Because
hours.
she'd have to then get the complaints prepared. So, that's a lot for her.
So you have the issue of room availability, which I know between now and the end of the year, talking to building management, rooms are very tight as far as their availability. And then the next thing is gathering all the information as far as complaints to set an agenda. And
Sounds
giving
like December
proper notice to the
It's
respondents
December.
and complainants.
I'm going to leave it to Madam Clerk, so she can't come up with all this in this month. So so you know what, let's do this in December, and Madam Clerk, if you can come back to us about dates available, that would be appreciated, and then...
I was going to say, is there any way that we can get dates sooner rather than later so that we're not...
Yeah, she'll say, yeah.
I can
Like
actually,
even before the meeting?
right, I can actually send an email to building management this week and ask for all availability for December up to the 20th.
Yeah.
Perfect.
Thank you.
So,
Let's not play kill the clerk.
Do we need to vote?
Yeah, wait,
so.
remember Pilpel?
I don't think we need to vote on this. I think we're just sort of giving
Yeah, we should
direction.
just do it.
If we do start this in December, I have no objection. If we want to try for the first Wednesday for the regular, as we've been doing, and maybe the third Wednesday if we can. If
Are you
we-
saying in December?
Yeah, but at this point, I would suggest that we sort of try it for a few months and see where we are with the backlog. I don't think it's going to take just one meeting to
No,
get through
that's
this,
true,
so-
but that's I would like to get that pat
Yeah,
and
no,
stuff,
you need to
and then
try-
she will
Right.
definitely,
What I'm saying is when we're reserving a room, that it not just be a one-time, that we look for
oh, I see what you're saying.
availability, and if it means that we're in 406 on the third Wednesday and only in here
Oh,
for the
it's fine.
first, so be it.
Yeah.
Just so long as we can make it work.
Yes.
And I agree with your approach to just have complaints and public comment at that second meeting.
Yeah.
So would it help to tell Madam Clerk the days that we think we might be available other than others? I mean, Tuesday doesn't work for you, if I remember.
No, it does now.
Does now?
I'm totally free Tuesdays.
So,
So the other thing is,
And you're
because
proud of that.
we can get to this later, but because the January meeting is going to be, can you pull up that calendar?
The variable, DCA Lee, are you with us? Or can you stay with us?
So we
Everett?
won't do that
Left out
January
variable.
meeting because January is January 1st, is New Year's Day. So we would move that meeting anyway. So let's plan on moving that meeting to the week after. Yes, sir.
happily, there's 5 Wednesdays in January, so we could actually do
Say it again?
There's 5 Wednesdays in January.
Yeah,
Could do the 8th and the 22nd, for example?
yeah, or the 29th.
Or the 29th.
Remember me?
Just one cautionary note on Tuesdays, and that we used to meet on Tuesday, and then one of the major reasons we changed is that it conflicts with Board of Supervisors meetings, and a lot of members of the public, pointed that out to us, and the reason we've changed to Wednesdays is really to accommodate that.
Got it.
Oh, yeah, if we do it Tuesday, we're bumping up against them.
So the Board of Supervisors meets every Tuesday?
Yeah.
Except
Okay.
for holidays.
So we'll just do it Wednesday, see if we can get the room Wednesday, January 8th, and then Wednesday, either the 22nd or the 29th. We can keep it on that same day. That's better, right, for everyone? And then if anyone, not necessarily? Okay, so
Tough for me as it is.
Wednesdays are hard. Okay, so let's just see what days the room is available, and then we'll move from there. Okay, for December and January.
Since
Yes.
we raised the concern, Deputy City Attorney Lee, how are we on time and budget
I
for
already asked her, she nodded.
nodded in
She said
the...
you're good.
Holding a second meeting?
If we have a second meeting that would require your attendance until
Can we
9
keep you?
o'clock, are we,
Great.
We don't have to give you
for
back.
the moment?
Great, for a couple of extra meetings for now, and then we can worry about that.
I like
Great,
puppies we have
thanks.
to give back.
Okay, so we will add this, you will look into that, and we will move forward on that. There's no vote or anything about this, so I'd like to move to the next item on the agenda, which is regular public comment. I'll leave you to say that. And I'd like to get, regular public comment. And Madam Clerk, can you put 3 minutes on the time? Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I was in the military for 12 years, and I worked with the federal, state, and local government in Hawaii for another 14 years, but I don't go in for gobbledygook. The 3-minute rule. If you study the open government laws such as the Sunshine Ordinance, the Brown Act, the California Public Records Act, and if you also go into some of the legal decisions that are issued resulting in cases relating to those, one of the themes you find that goes consistently through all of them is that laws, rules, whatever it is, are to be interpreted in a way that provides maximum access to the public. I would like to propose, since it's been mentioned a couple of times already tonight and in previous sessions, that the reading of the ordinance be considered in this way. A member of the public may have up to 3 minutes to speak. That is, to me, a reading that I may choose to speak for 1 minute, I may choose to speak for 2 minutes, I may choose to speak for 3 minutes, because that is my right under the Constitution of the State of California and the United States to decide how long I want to talk. It is, on the alternative, not the position of the body to determine the extent of my constitutional rights and my ability to exercise them. It is very convenient to read something in a way that you say, oh, well, good, I can cut this down to 2 minutes. I can cut this down to 1 minute. I can cut it down to 30. When do we get to 5 seconds? And you say, oh, well, that's never going to happen. Yeah. I said it when the Board of Supervisors went to 2 minutes, that very soon other city bodies would start to follow suit and restrict public comment to 2 minutes. I think you must consider the fact that in all the law relating to open government, it has been made very clear that the readings are to provide maximum access, and this law says a speaker shall have up to 3 minutes. And I read that, as I've said before, as I can choose to talk for less than 3, but I can have up to 3. That's what the law says. And that's pretty plain English reading in my book. And for the bodies to turn around and say, oh no, what that means is we get to restrict your First Amendment rights under the Constitution of the United States or under the Constitution of the State of California is an egregiously bad reading, especially when every member of these boards and commissions takes an oath to support and defend the Constitution of the United States and of the State of California.
Good evening again, Patrick Manette-Shaw. If this body is not already aware of lawyer Alan Grossman's victory in Superior Court against Mr. St. Croix, you should rapidly become aware of it. In part, because Mr. Todd David blatantly appears on audio tape of the August 7th Sunshine Task Force meeting, in which he says, quote, and I'm kind of the mind that if, you know, the city attorney is elected by the people of San Francisco, and if they disagree with his interpretation of the Sunshine Ordinance and the state of California's Constitution, he can be replaced. That is brazenly arrogant. That is no justification for deciding whether there's a catch-22 between what the city attorney advises city departments such as Rec and Park that you will be hearing on agenda item 4 tonight. Mr. Grossman proved that you don't need to replace the city attorney to challenge the city attorney's ridiculous advice to city departments. You can march into Superior Court if you have the time, the wherewithal, the resources, and the money. And you can beat Mr. Herrera at his own game, Member David, in Superior Court. You don't have to wait for an election in which Mr. Herrera has no opponent. When you face conflicts between what the city attorney is wrongly advising city departments and language in the Sunshine Ordinance, you should bear in mind that members of the public who do have the wherewithal and the resources to file Superior Court cases could easily file one against you, Mr. David, or against you, Chair Grant, for restricting the 3-minute public comment period. How would you like a Superior Court judge ruling that your personal biases are interfering with the voters' rights under Sunshine Ordinance.
Thank you. Is there any more public comment?
Hi, you guys. My name is Paula Dadish, and there's a complaint that's pending before you, the Clark brothers, and I just want to tell you personally what was done to me. My permit, street artist permit, was revoked illegally 3 separate times in the course of 15 years. I was not served properly the first time. I didn't even know about a hearing. I did everything within my power to make it known. I spent $10,000 in legal fees fighting the city attorney's office in what was my First Amendment right, my rights under the California law and the Brown Act. I recall even James Chafee went in at one point to hand an application years ago. It was almost 20 years ago, the first time my permit was revoked illegally. I got a de facto appeal, which is how I got the permit back the first time. The second time was pretty much the same thing. I believe it was in 2003. I was denied due process, even under the laws of the Street Artist Program, which are very vague, written by Howard Lazar, and not available to the public, or they weren't at that time. So the second time I went on appeal, finding no legal basis for them to have denied my permit. And the third one, as you know, was this past year in a retaliation attempt, simply because I filed sunshine complaints before this committee. I am still being retaliated against in the street, which is why I almost never work. So from personal experience, I can tell you that when you have one person who's been in the same job for 41 years, who basically bends the law at his own will and uses legal opinions or advice from the city attorney's office to disguise or to not give over information, it really it has affected me. The first 2 times I went before the Board of Permits and Appeals, I felt I was a bad person or a bad artist or I'd done something wrong. That's not true. It's just been Lazar bending the rules. Thank you.
Thank you.
Good afternoon, Task Force members. Stop the corporate rape of our public library. Don't give money to Friends of the Library. Don't accept money from Friends of the Library. This is now the second part of a 3-part presentation, and my graphics reflect the actual documents. On September 19, I hope you know that the California Fair Political Practices Commission in Sacramento found City Librarian Luis Herrera guilty of 3 years of violations for failure to report gifts. These are laws that are designed to prevent those who are supposed to represent the public from representing the interests who give them money instead. In order for the society to protect itself, the city librarian has to sign every other year under penalty of perjury that he attended ethics training on the reporting of gifts. In order for the society to protect itself, the city librarian has to sign every year under penalty of perjury that he has taken sunshine training, including reporting gifts. After that, the city librarian signed under penalty of perjury that he had, quote, nothing to report, unquote, while he was receiving $65,000 per year from the Friends of the Library. These statements under penalty of perjury had no effect in inducing the city librarian to make the required disclosures. The reason for the signature under penalty of perjury to make every violation a willful and knowledgeable violation. Advice from the city attorney's office, from the library department's accountants, from the controller's office, and from the lawyers from the private nonprofit providing the money had no effect in inducing the city librarian to make the required disclosures. It goes without saying that oversight from either the Ethics Commission or the mayor's office had no effect in inducing compliance with the law. We don't have laws regarding disclosure of gifts because everyone hates Christmas. The laws are to protect the potential of conflict of interest so that we have some notice of officials doing favors for private wealth that is giving the gifts. In the 12 years that the Friends have been raising funds for the Branch Library Improvement Program, the Friends of the Library expended $53 million. The amount expended to benefit the public library was $5.1 million, or 9.6% of that total. The Friends of the Library have no agreement with the city. They have an agreement with the city librarian, and it's been acknowledged that the quarterly reports that were required to be submitted under that agreement were never produced. That's the payoff for the gifts. There's no accountability for the raising of that money. You are particularly important because you've been monitoring, you've been privy to the fact that in 2 years it took Ray Hartz to get the incriminating documents that should have been public documents in the first place. The point is that I think you get the point. Thank you.
Thank you very much.
Entertaining as always.
It's a great presentation.
According to the Brown Act, no action or discussion shall be undertaken on any item not appearing on the posted agenda, except that members of a legislative body or its staff may briefly respond to statements made or questions posed by persons exercising their public testimony rights under this law. So, some of you will recall that 2 months ago, you referred a case I had, a complaint I had for enforcement to the Ethics Commission. That referral still hasn't gotten there. So I understand the chair is knowledgeable on this subject, and I'd appreciate some response.
Yes, I have done the letter. It has to go to our attorney, who has not had a chance. I'll let him respond.
Who would that
I haven't had a chance to
Well,
review the letter.
I'd appreciate it if you would please do that. Thank you very much, Mr. Sims.
I was going to finish.
Now, my public comment on, I think we're on agenda item, 4?
You're in public. I moved it. We are on public comment, so the next item after you will be item 4.
Right. I have about 2 minutes, so I'll try to make this short. I think part of the problem is that in May of 2012, when the board replaced all of the members, except the 2 that are sitting here, and possibly Mr. Propel, with a new group who had never attended a task force meeting prior to their appointment, who had never filed a complaint, had never sat and talked to anybody, and certainly were not familiar with all the rules. So what's happened is that there's a sort of dysfunction. You're missing 2 out of your 11 members. You made no effort to get the board to fill those seats, so you're doing more work. And as a result, you have a very slow-moving train with a lot of baggage to carry. It's also been made pretty clear in my dealings with some of the departments and agencies that they now know what's going on here in ethics, which is between the 2 policy bodies, there's almost no action to move Sunshine forward. And that's why I had to file a lawsuit, because it was clear to me that the referral would never, even if it got to ethics, nothing would happen to it. So I think it's important that those of you who actually probably didn't want to serve on the task force but were asked to, hopefully will develop the passion that all of us who've been here and done this have. Thank you.
Thank you. I'd like to make one comment to Mr. Grossman, just for your own information. 4 members of this committee have gone to the various supervisors and requested movement on getting the new members. So just so you
And
know
what
that.
was their response?
Their response is that they're working on it.
They're working on it. Do you remember the meeting in May of last year? Mm-hmm. You sure do. Mm-hmm. That's over a year, almost and 6 months. That's a year and a half.
And we've gone subsequently
Yeah.
to them, so
Thank you.
just to let you know. Great. Is there any more public comment?
Yes, Peter Warfield, Executive Director of Library Users Association. There's quite a bit to say, and I'll try and include everything. Alan Grossman's suit in Superior Court got a ruling from the judge that said he was right and that the Ethics Commission was wrong in withholding its documents from him, and they had the city attorney in the courtroom where I was too, as an observer, defending the Ethics Commission's right to withhold. The city attorney lost. Apparently that's now being appealed by the city. On September 19th, the Fair Political Practices Commission found Luis Herrera had violated in 3 successive years the law which requires him to reveal and to state what gifts he had received. It was a 700 form in each of 3 years that he had filed in which he swore under penalty of perjury that he had used the best of his knowledge and that this was truthful, and he had nothing to report. He put an X in the box that said nothing to report. The FPPC fined him, unfortunately, a minimal fine of $200 per offense, $600 total, but nonetheless he was found in violation of the law. Ray Hartz appeared before the Board of Supervisors on October 22nd and was taken out in shackles. A shocking experience which I recommend you watch during public comment for that meeting. There may be more to be said about that later, but that was pretty shocking. I want to make some suggestions with respect to your future activities. I think you really need to be serious about dealing with repeat violations, whether within a department or amongst departments. Otherwise, you'll be endlessly sort of smacking at mice or cockroaches, rather than saying there's an infestation. In connection with that, it would be useful for you to send out things that such as you have sent before, which is basically an all-points bulletin to the department saying you've determined that such and such is a practice or a habitual violation. This is your decision about that, and this is what you expect in the future, and if anybody violates it, they're going to fast get a violation. I also think you might consider changes to provide earlier distribution of your agenda packets. You've got 327 pages this time. I don't think 3 days is sufficient. 3 minutes, thank you very much, should be for every public comment here.
Hello. Once again, my name is Jason Grant Garza, and I'm here because, the chair afforded Mr. Grossman a response to his question, and I hope that you do the same with me. As I stated earlier, I have informed the SOTF of a hearing request on 9/26. Will I get a response from these people, or will I have to be here next month again to continue to prove how the system is rigged to fail, because I have not even had an acknowledgement of that receipt or anything else? Do your policies work, madam? And if so, what is the accountability of not having performed correctly? Will I or will I not receive, what I was supposed to have received in this requested hearing request? The administrator said there was 15 filed in September. Well, excuse me, I had 2 more that were filed in September that apparently nobody's responded to. Interesting, isn't it? Subterfuge, delay. Well, when I talk about this isn't the first time this has happened about the 45-day rule. I have got voluminous amounts of paperwork regarding these issues from 10 years ago, 5 years ago. Nothing changes. You guys all change. New players. The same crappy, lousy, unaccountable system continues. Now, I would like to know as a citizen what I have done wrong by following what was supposedly in Sunshine, what was supposedly my right, and yet being treated without dignity, without respect, without even an acknowledgement. because everything was emailed, and trust me, I have the documentation. So how can you judge anybody else when you can't even live within your own rules? To me, that is beyond hypocritical. And as I've stated before, will I have to be in here next month again pointing out that I still haven't been answered? What is being done to address this specific lack of correct performance? I'm awaiting an answer.
Can I follow up on that briefly?
Deer in the headlights, folks. I'm awaiting an answer. I'll be here for 48 more minutes awaiting an answer, just to show the shield for the city. You know, you're supposed to be protecting my rights. So I take it I'll be here next month again when I still haven't been responded to appropriately? Mind you, this is going on YouTube. The Ministry of Sunshine. You have a 45-day rule. 17 more seconds for an answer. You sure you guys don't want to do the right thing? Thank you. Your silence speaks abundantly as to the rigged methodology, the lack of humanity, and the fact that this is the Ministry of Sunshine with no sunshine.
Is there any more public comment? If not, public comment is closed. I would like to go to the next item on the agenda, and then we can take a break, which would be number 4.
Item number 7, file number...
No, 4. Remember to go back.
I'm sorry. Item number 4, file number 12058. Compliance and Amendments Committee has referred file number...
Guys, the kid on this.
File number 12058, Dominic Manucci against Recreation and Park for allegedly failing to provide records requested pertaining to birthing contracts.
Great. I'd like to ask Member Washburn to kind of update us on this case before we ask the parties to come up, since it was seen before, compliance amendments.
All right. Compliance and amendments did a follow-up on this matter in July, at our July 16 meeting. Heard from the complainant and from Ms. Gong representing Rec and Park. Nothing at all had changed. The complainant had not received unredacted records that we had determined that he should obtain. And we voted to refer this matter back to the full task force with the recommendation for referral to the Ethics Commission for enforcement. And we found actually willful violation on the part of the city attorney for working with a city department to prevent public records from being disclosed. Does anyone have anything to add?
I believe that wasn't the request, because it wasn't just that we asked who's the head of this department?
Well, we wanted someone here who could shed more light on what was happening at Rec and Park. We've always heard from Ms. Gong, who helps us to the best of her ability to understand the matter. But we wanted to hear from Mr. Ginsburg.
So
I see Ms. Gong here today.
Yeah. So Madam Clerk, didn't you put a specific request? That was what was decided, that we wanted to invite Mr. Ginsburg here to specifically respond to questions that that Dominic had, we felt that he was more able to answer. So you did send that.
Correct. The notice went to Ms. Gong, the Director of Recreation and Park, along with Ms. Gong's supervisor. That was a request also. I can't remember her name at this point, but all three.
Sarah Ballard.
Thank you, yes.
Okay.
And that email is in our packet somewhere.
Yes, so that was what I think, because I don't believe that was what was decided, because we didn't decide to send a referral straight to ethics. That was what we requested. Mr. Mianki was amenable to that, and that was the reason we are hearing him again before we make a determination to send it to ethics. That was my recollection. And
Well, I'm just reporting on what the motion is, and the motion and the minutes, the draft minutes. The wording was what I said, that we moved to refer the matter back to the task force with the recommendation of referral to the Ethics Commission.
Got it, okay.
So we were frustrated in that we weren't able to speak with anyone other than Ms. Gong.
Great. And you're right, Ms. Gong is here. But Mr. Mianki, would you like to come up and kind of update us on anything, if anything has changed? Since the last time, you have 5 minutes.
Emails on page 30.
Well, not much has changed. I mean, I still have the documents, as we all know.
Mm-hmm.
But I believe they submitted a new letter and then resubmitted, at least I should have brought it. I was in a rush today.
We have it.
There was a new letter submitted, and it was signed by Ms. Gong. But again, I don't, I can't say this because I don't know who wrote it, but I'd like you to ask Ms. Gong, it's up to you, who wrote it for her. Because again, it sounds like I'm dealing direct, it's like me against the city attorney's office. She obviously didn't write that 10-page paper with citing all the cases, and then she said she didn't know who wrote it, and then she said that maybe the city, that was kind of a convoluted answer that none of us. Again, there's another document submitted. I hope you have it. And again, I feel like it's me against not Rec and Park. It's me against the city attorney. The city attorney is supposed to be unbiased, but in my experience, they back up departments more likely than not. And that leads me to last time I made a comment that Todd David said he was going to vote against me, and I guess after looking at the tape again, he never said that. He said that if we refer this on to the Ethics Commission, I think we all know the Ethics Commission is going to say that they didn't violate, that they did not have to disclose, that they don't have to remove the redactions. That he did say. However, I took that to mean that because of that, he would vote against any referral to the Ethics Commission because it was a waste of time. I read into what he said. I just want to make that correction. Again, the city attorney's office, in my experience, is first of all, I believe you've talked about this before, and I haven't had time to read all the ordinances, but I think the city attorney's office is allowed to be an advocate for a department head, but not for an employee like Ms. Gong. So if he's writing these documents and having her sign them, I think that is a violation. And your body probably knows more about these rules than I do. But I just want to mention that, if she signs something that, I believe that she should be the one writing it, not the city attorney writing it for her. That's about it. I hope, like Mr. Oka suggested, he would not vote for it unless it was considered a willful violation. I agree with that. Don't even waste my time going there to the Ethics Commission unless you all agree it's willful. We can just drop it here. I think that would be a big mistake. But, unless you put some teeth in some of this, or as much as you possibly can, I think it is a waste of time for all of us, including yourselves and me, because we were all trying to do the same thing. I mean, at this point, it doesn't even matter if I get those 4 documents anymore. You probably realize that. I mean, it's been a year and a half. Mm-hmm. Now it's just a question of Rec and Park is constantly saying no. They probably know you have a backlog. They don't come to the meetings. I mean, it's a total, it's a sign of disrespect from one department to another. And this is now we're at the principle of the matter, not the actual documents. Mm-hmm. Are probably not even important anymore, and that's why I continue to keep on coming. Anyway, that's it.
Okay, thank you so much. Is there anyone here that wants to offer any facts or evidence in support of Mr. Mianki?
I would like to speak in support of Dominic by adding some facts that you are aware of, and I apologize, I don't want to butcher pronunciation of his last name. But there was an extended conversation last meeting of the Sunshine Task Force in which it sounded like Mr. Ginsburg was being ordered to attend tonight's meeting. I don't know that an invitation or couching it as an invitation is quite the same thing as issuing an order to him to appear. But by his failure to be here tonight and his insistence on throwing Miss Gong to the wolves, throwing her on his pitchfork, it can be construed only as willful failure. This task force needs to find the wherewithal as you debate Dominic's case tonight to make a referral to ethics as a willful violation. It's ethically incumbent upon you to do that in part because of Mr. Grossman's victory in Superior Court. Perhaps Dominic doesn't have the resources to pursue this matter in Superior Court, but he has every right to ask that you send it to ethics for enforcement as a willful violation. And to that end, Mr. David, because he said as well on August 7th. And so it becomes just a circular conversation. Because we're going to vote and we're going to say there's a willful violation, they did not do what we told them to do. Then it's going to go to ethics, and ethics is most likely going to say, exposing his bias for prejudging what ethics may or may not do. Ethics is most likely going to say what they, the respondent, did was absolutely fine. And so it becomes just a circular conversation. And I, Mr. David, don't see how that's at all helpful. It's not up to members of this body to decide whether a referral to ethics is or is not helpful. The issue is whether there's been a willful violation that should be forwarded to ethics. And because Todd David has exposed his bias, he should recuse himself from this vote.
Thank you, sir.
Members of the Task Force, Ray Hartz, Director, San Francisco Open Government. I think this case is an exemplar of what you see in many boards, commissions, especially when someone files a complaint with either Sunshine or the Ethics Commission. You have a member of a board or commission or a city official who takes an action and then doesn't have the dignity or the whatever you want to call it to show up and defend and explain their own actions. So what they do is they take an employee, in this case Mr. Ginsburg sends Ms. Gong and says, you go answer for what I did. And it's really, to me, nothing but cowardice. As I've told you before, I served in the military for 12 years. And one of the things you learn in an organization like that is when you're in command, if you're in charge, you're responsible. And if you are a commanding officer and something happens on your ship, whether you had anything to do with it at all, it is still your responsibility because it happened under your watch. This case happened under Mr. Ginsburg's watch, and he has studiously avoided sending anyone that could really answer the questions that many of you have asked. He has explicitly and very carefully made sure that he never showed up. So in other words, I, as a member of a board or commission, have the balls, excuse my French, but to tell you something that's wrong or illegal, to order action, to order an employee to act in an illegal fashion or whatever it is, and then when someone calls me on it, I don't have the dignity to show up and explain my own actions. It happens when the Library Commission and the city librarian do it, they send Sue Blackman, the secretary. It happens when the police department does it, they send the Inspector Monroe, who's the secretary of the police commission. None of these people, all who take the Sunshine Ordinance training and the Ethics Commission training and sign affidavits saying they understand the law and their duties under the law, have the moral courage to come here and say, I did this because of this. Instead, they throw their employees on the fire, put them out there and actually expose them to unfair criticism, because how are they supposed to know what this person was thinking when they did what they did? The only person that can answer that type of a question is the person. But when you're the kind of a person who hasn't got the integrity to take responsibility for your own action, I think that speaks much more loudly about you as an individual than anything else possibly could.
Thank you. Is there anyone else that wants to offer any support for Mr. Bianchi?
No.
This is offering support for any evidence or facts from Mr. Bianchi. If not, no. I would like to invite Ms. Gong up here as the respondent.
Good evening.
Hi, how are you?
Good. How are you?
So you have 5 minutes, kind of if you could update us. We had asked Mr. Ginsburg to come. I don't know if you have a response from him or anything more to offer us.
Actually, I do not have anything else to offer than what we have already provided. Again, in our letter, we said that we are not under willful violation. We have not committed a willful violation. The Ethics Commission's regulations for violations of the Sunshine Ordinance define willful violation as an action or failure to act with the knowledge that such an act or failure to act was a violation of the Sunshine Ordinance. A department's disagreement with the task force interpretation of the Sunshine Ordinance does not constitute a willful violation. Further, in deciding to withhold from disclosure the individual's home addresses and phone numbers to protect their right to privacy, the department sought and followed the advice of the city attorney's office. That's all I have to say. Nothing different than what has already been said.
Okay, thank you.
Ms. Gong,
Wait, let me ask, do you have anybody here to support you, offer any facts or evidence?
I don't think so.
Okay, all right. You see someone? Oh, then we do have a question for you. I just wanted to go through the process.
So just because you brought up an interesting point and you said, and I'm going to just paraphrase what you said, is that it cannot be a willful violation because the Rexon Park disagrees with the Sunshine Ordinance Task Force interpretation of the Sunshine Ordinance, which is our duty to interpret, correct?
Whoa, that was a long sentence.
Yeah, I'm sorry. Maybe I'll make it shorter. Basically, what you're saying is it can't be willful because we disagree with your interpretation of the Sunshine Ordinance, correct?
No, I'm saying that the definition of a willful violation is an action or failure to act with the knowledge that such an act or failure to act is a violation of the Sunshine Ordinance. Rather, instead, we are disagreeing with your interpretation of the Sunshine Ordinance, but that does not constitute a willful violation.
So
our disagreement does not constitute a willful violation.
So going back to the first time when this body ordered you to produce the documents because failure to produce the documents was a violation of the Sunshine Ordinance. What was your response to this body as well as to the, what was it, Education, Outreach, and Training?
Compliance amendments.
Compliance amendments order, I'm sorry.
We produce documents, it's just that we produced them with redactions because we are trying to protect the privacy of individuals.
We understand that, and our order was that that your
Page 15 shall release.
your reasoning was faulty, and our order was that you to produce the documents without the redaction, and you failed to comply with that order, correct?
Correct. We believe we are lawful in redacting the documents.
Exactly, and we told you that you were not.
I think you did.
Yes. So then, based upon our given duty and responsibility as the body that interprets the Sunshine Ordinance, and we've told you that you are in violation of the Sunshine Ordinance and that failure to produce the documents, which you failed to produce, unredacted, that we ordered you to produce, unredacted, how can you now say that you're not being in willful violation of our original order, which showed you that your actions were in violation of the Sunshine Ordinance?
We are still disagreeing with your interpretation of the Sunshine Ordinance.
Okay. I guess that is your argument.
Member David has a question?
So, Ms. Gong, I guess my question, I know my question is, in order to get this resolved, right, one way or the other, it seems like resolution is not going to happen at the Sunshine Task Force, that we need to then refer it up to ethics to get them to make a decision as to whether I happen to agree with you, but I have been on the other side of the vote on every one of these issues, and it doesn't seem like that there's any other way to resolve this issue than for us to vote it to ethics, so that therefore you can make your both sides can make their argument to ethics, and you'll get a decision from the from ethics. Does that, I mean, is that, I don't know how, I guess from your point of view, how else can you see this issue being resolved, being that it has already been voted on multiple times here that you've been found in violation? So,
I don't think that's my decision.
Okay. That's fine. Very good.
Thank you. Is there any? Oh, Member Sims.
My also question is for you, because I mean, I feel like, from my opinion, we're going to refer you to ethics. It's just whether we refer you to willful or not willful violation. And I do have trouble that when you first came here and we discussed the case law that the city attorney quoted to you, and the case law actually was not supportive of your position. On point. Not a case law I cited, but case law the city attorney or yourself, since you signed the letter, cited, was supportive of the position that you should produce the documents unredacted. So with that, I can't really follow your analysis that it's not a willful violation. Because you've been given reasoning why, you've been given clear guidance, legal guidance by clear interpretation of why these set of circumstances apply to the case law you cited, which you failed to, in your actual letter, cite the circumstances of this case to the case law. You cited the case law, but then, when you cited the case law, you didn't apply them to the facts. You just said, we're not producing, essentially. Cite, and then not applying to the facts. So I think that is why, in this case, I would be voting to find a willful violation.
Member Nee?
Ms. Gong, I guess there's been a letter recently that you submitted on this matter. Is that correct?
No, I mean, we have not submitted a new letter
Okay.
recently. It's been the same letter for the last, I think, 3 or 4 hearings. There has been no changes.
And you're the signature of that letter. Who wrote that? Are you the one who actually wrote the letter? And if not, who did?
I am the custodian of records. I'm responsible for writing these letters to the
ma'am.
task force.
But my question.
I might have had
My
help.
question is, who wrote the letter we're discussing here?
Which one are you discussing? Which letter?
Dated July 29th in the packet, page 3233.
July 9th.
July 29th.
29th, 2013.
$19?
April. Well,
Page 32, you said?
What is it?
Well, I signed all the letters that were submitted, so I'm responsible ultimately for the letters. I mean, I may have had help in the draft, but, I'm responsible for the letters. I signed the letters. I mean, I don't understand.
Who helped you in the draft?
We consult our city attorney, Francesca, and then we write the letters, and I sign it.
Thank you.
It represents our department's view,
And I'm sorry.
I don't understand what the controversy is on who wrote the exact words.
I think, who writes the letters that you sign, I think is relevant to what we're looking at here. Was it, if it was Ms. Ginsburg, if it was somebody else within your department, or if, in fact, it was a member of the city attorney staff who wrote that letter. I think that's relevant. I think that's something we all want to know.
Well, I definitely drafted it and signed it.
Thank you.
Member Pilpel?
I still like the fact that it says Mayor Gavin Newsom on the top 2.5 years after he's gone. Anyway,
Yeah.
I was just referencing that it still says Mayor Gavin Newsom on the letterhead. Can you talk? Could you talk for a moment about the right to privacy? My understanding is that the privacy in this instance is not an absolute, but it's a qualified or balancing issue. So how does your department view the individual's right to privacy relative to the public's interest in disclosure? And I know that we've already heard the matter, so I'm just trying to understand that further as it relates to the question of willful, because I'm actually very much on the fence about, I'm not on the fence about there having been a violation. I'm not on the fence about being willing to refer to the Ethics Commission. I am on the fence about whether there's been a willful violation or not a willful violation, and so understanding that privacy balancing is important to my decision-making in the matter. I hope that makes sense to folks. So, I'm sorry, if you could address that question of how you conduct the privacy balancing in general or in specific in this instance.
I'm not sure. Can you rephrase your question?
Okay. In your letter that we've been talking about, you refer to, in deciding to withhold from disclosure the individual's home addresses and phone numbers to protect their right to privacy, the department sought and followed the advice of the city attorney's office. Indeed, the good government guide instructs, da-da-da-da. So in making the judgment call about whether to redact personal contact information, what factors do you take into account about the individual's right to privacy and the public's interest in disclosure?
The applicant's home address information does not shed light on the agency's activities, and the relevant public interest supporting disclosure in this case is negligible.
And I'm sorry, how do you make that determination, and where are you pulling that from?
I'm asking you, how does disclosing an applicant's home address information shed light on our agency's activity?
You're asking me that?
Yes. I'm saying the reason we are not disclosing is because the applicant's home address does not shed light on our agency's activities.
Okay. And how do you make that determination?
How?
And who, in fact, did you make that determination, or how was that determination? Somebody made that determination. Who made that determination, and how was that determination made?
It says, I'm reading from the letter, okay? There is no legitimate public interest served by mandating this disclosure. Disclosure of the information will not promote openness in government, nor will it shed light on our department's performance of its duties.
And who made that determination, and how was that determination made? I'm asking that again. I read what's in the letter. I'm asking you for information that's not in the letter.
Who is it? Well, the determination to not disclose is by our department. Our department decides that.
Who in your department made that determination in this instance?
Well, we of course, we ask our city attorney for
advice. And they
advice.
advise, and you decide. So who within the department made that determination?
This is our general policy.
No. In this particular instance, who made that specific call not to disclose the contact information? I'm sorry to keep on it, but it's sort of important.
It is important, but
we're not going to go on forever, but
because she obviously is giving you the answer the best to her ability, so we have to make a determination based on what she's saying. And she doesn't have an answer.
Do you have an answer?
I don't know.
And the city attorney is the one that helps you with that.
Advises, but the city attorney doesn't make decisions.
She's
for
not going to give you a
departments.
name. So.
Can you please... Yeah. Just stop. Can I make a comment? At the end of the day, the department head is in charge of decisions that are made at the department. And I just want to say that I think that at the end of the day, right, what happens at Rec and Park is ultimately Mr. Ginsburg's.
I'm not disagreeing with that.
So by pulling a name, she's not going to give us anything.
Okay. Can I ask?
Member Sims.
But you made an interesting, I guess, admission here, that it is the department policy, correct, to not disclose names at any point, for any reason. I'm sorry, not disclose names, not disclose home addresses and telephone numbers. That is your policy, blanket policy, correct?
I said, let me see. That is, in general, our policy. When I was trained as a custodian of records, that was what I was trained to do, to disclose all personal home addresses and information from public records before sending them out to the public.
Yes.
So that is our general public policy.
So the reasoning why I am leaning toward finding a willful violation is because they have asserted to us that they did a balancing act and looked at what was the party's need to actually have the names and addresses, which he has given his need to have the addresses and telephone numbers ad nauseum in these hearings we've had here. And we're clear of why he wanted them. And they said that reasoning wasn't good enough. But it's clear that reason was clear and articulated, as well as the fact that no matter what reasoning he gave, they were not going to produce these records. So, in my view, it's a willful violation, and that there's no excuse for them withholding the names and addresses based upon the information they had both at the time of the request, at the time of the hearing that we've had 2 or 3 times, after compliance, as well as previous hearings once this has come from compliance. So that's my thoughts.
So,
Great.
but to follow up, not with Ms. Gong, but amongst the task force, I prepared a document like 3 months ago, and I think I distributed it at the September meeting. I haven't done anything on it since. I think that whatever action we take, if it's to refer to the Ethics Commission, needs to have some verbiage with findings. That wasn't in the packet for whatever reason. I don't know where it is. I know that Member Washburn has it with her, which is great. I didn't bring mine with me. But again, and whether it's that language or some other language, I think we need to have language in here that doesn't just say we refer the matter, but that has some explanation so that it's more likely to be upheld, or we're just going through an exercise and the Ethics Commission will likely dismiss it in the absence of some compelling language. So I think we need to have that somehow, somewhere, and hopefully that's here somewhere tonight.
Yeah. Based upon what we decide, and I think we're leaning towards, I'm leaning towards willful violation. When we do the letter, I will work with Member Sims, and we will take your letter, and we can, get the correct verbiage and make it a bit more substantial, since they both parties have been here for the past few months. And thank you so much for coming, both of you, for this matter.
Is it possible to make one more comment? We'll take 15 seconds.
Sure, I haven't done the final things yet.
Madam Chair, quick question on procedure. If we're going to vote on willful violation, we're going to add 6734 to the 6726. How are we going to approach that?
It's how we choose to make the motion. So whoever chooses to make the motion, then we can make suggestions from that point. At this time, I'm sorry, Ms. Gong, do you have anything that you would like to say, final remarks? Did you say no? I can't.
She's away in the back. She said no.
Okay. Mr. Mianki?
Well, first, I'd like to mention that I believe the file is incomplete, and again, it's because I rushed here. I received an email saying there was, where they submitted that same old letter again, with, referring to case law, but there was also a cover letter to it. Maybe I'm crazy again and made a mistake, but I think it's missing. But I'll email it if I can find it, I will add it I will send it to the SOTF and have them add it to the file for you. But that's not real important. What is important is you asked Ms. Gong if it's a policy. She claims it's a policy of Rec and Park not to give out addresses, and then she cites all those cases. However, that's absolutely incorrect. And you have the own proof by looking back on your computer and looking at a case I brought 3 years ago where I asked for birthing agreements, and the birthing and they were redacted, and and there was a determination from your board. I don't know how many members were still there or not. Oh, okay. But they agreed with me, and they handed over the documents. And since then, on many occasions, I ask for birthing agreements, and I get their phone number, and I get their address. So it is not a blanket policy. I just want you to really understand that. So if they're relying on a blanket policy, that is incorrect, and you can find it in your own records. Now, the fallacy of all this, is that they just don't want me to give out those records. This is willful, and let me explain why. And Mr. David, I want you to I want to convince you, okay? Once these people apply for a birth, they pay money and they get on a wait list. It's a contract, because every year if you don't pay the money, you're not on the wait list anymore. So it's a contract of some sorts. It's a contract. The ordinance says contracts have to be provided completely, because you have to know who's giving the money for whatever reason. It's public policy. Now, once these people get a birth, then I can ask for that birth, and they will give me the name and phone number. So it's almost ludicrous to make a distinction between the wait list and and a birthing license, because once these, presuming all these people want a birth, they will eventually get a birth, and then I can ask for the birth, and it's been decided, and they've been complying with this for 3 years. Every time I ask for a birthing license, I get it unredacted. So don't make your decision based on their policy. I mean, I hope you can see that, Mr. David, that it's inevitable that I will get their name and phone number.
I believe the distinction before, if I remember correctly, was that what the original debate was the contract, right? And I think it's a reasonable argument to say that you're paying $50 to get on a waiting list. I think a reasonable person can say that is a contract. I think that there's another side of that argument that's a reasonable people could say that's getting on a wait list. I mean, so that's...
If I don't pay for my $50, I will not be on it.
No, I understand. I'm just saying that that's where... I think that once you are in where everyone agrees there's a contract with the city to have a birthing place, I don't think there's any debate as to what is public information, what is not. I just want to. Okay, I just want to point out.
In my opinion, that's a stretched argument. But, that's just my opinion. Sure. But at the same time, it is. But you still can't say that it's a general policy of Rec and Park not to give out addresses, because you just said that when it's a contract, you have to give out addresses.
So I think what you're saying is that the expectation of privacy, especially when you get the contract, is one that, that information is going to be available publicly. That's what you're trying to drive at.
Well, it's actually written in the ordinance. There's one little line that says contracts are available. And if you go to if you go higher up to the Public Records Act, it also says that you have to presume everything is, you all know this, so I'm not going to go into it again.
Thank you very much.
Thank you.
Okay, at this time, I'd like to know if we have a motion. Member Washburn?
I just wanted, there was another wrinkle to this that I thought was interesting and pertinent, and that's that the reason you wanted to see the wait list, that information, there was some question about whether people were being taken in order. So the question has to do with the actual day-to-day operation of Rec and Park. So those records were needed to understand the day-to-day operations of Rec and Park. And the Sunshine Ordinance says that information of that, like that, is public record. And that's a very important distinction here. It's not a mere contract. We could decide it's a contract. It has to do with transparency of how Rec and Park handles their wait list, which ought to be handled in the way they say it's handled. And they should be accountable and should be able to be followed up upon.
At this time, I'd like to know if there is a motion to find a violation of the Sunshine Ordinance.
Well, the violation's already been found.
Anything
We're not
additional?
re-adjudicating here. Madam Chair,
Is there anything more?
I move to refer this matter to the Ethics Commission on the following grounds. Sunshine Ordinance Section 67.21E for failure on the part of the Department of Recreation and Park to send a representative who was sufficiently knowledgeable in this matter. There was simply too much information that Ms. Gong was unable to provide to us, and I'm not faulting Ms. Gong for that. Second, Section 67.24G. Ms. Gong, in her presentation, mentioned that the department feels that providing the contact information will not increase accountability or transparency. Section 6255 of the California Public Records Act allows that kind of a balancing test. However, Section 67.24G of the Sunshine Ordinance specifically prohibits that kind of a balancing test and mentions 6255. So 6255 is overridden here. Third, as in the original finding of the task force and order of determination, Section 67.26, failure to keep withholding to a minimum. Finally, Section 67.34. I believe, as a number of my colleagues do, that this is in fact a willful violation, and I will tell you why. Ms. Gong said willful violation occurs when you are knowingly violating the law. When there is knowledge of violating the law. In the previous proceedings on this matter, the task force gave that knowledge. We asked Ms. Gong in previous proceedings if there was any effort to ask people whose information was redacted if they wanted that information redacted. The response was no. Was there any indication that the department plans to do this henceforth? Again, the response was no. Had the department sought any evidence that anyone would have a personal safety risk through the release of the contact information? Again, the answer was no. So again, there is willfulness throughout this entire matter. Ms. Gong cited city attorney advice. Two things. First of all, the city attorney advice is not law. Second, and this is a rather extreme analogy, but if your attorney goes out and says, yeah, it's okay to off this guy because you don't like him or because he did something bad to you, that's, you still know that, well, maybe it's not legal to go out and off this guy. The task force has held in numerous similar cases that personal information is not to be redacted on a broad basis, that it has to be narrowly defined, narrowly determined. And those determinations have, the votes to uphold those determinations have included votes from our own voting attorneys. So the fact that the city attorney gives this advice, again, we have countervailing advice that includes our own attorneys, our own voting attorneys' opinions. I guess I've already orated too much, absent a second.
I'll second it.
But I've given my reasoning.
It's been moved and seconded. Second. Ken, were you going to say? What? Member Pilpel?
I
know.
I had a couple of niggling concerns, but I'll let them go. I'm still a bit on the fence on this question of willful. I think in this case, whatever transmittal letter we send, again, with background and findings and whatever, I think, and maybe I need to ask Ms. Lee on this, does that background, verbiage, findings, does that need to be acted on by the body, or is crafting that referral in this case something that we can delegate? Because I want to, for some reason, I would really prefer not to blow this, and I would rather that we do it right, and that if we need to have the verbiage before us and vote on it as a body, that we do that, and if that isn't here, then whatever we need to do. But I don't want for someone to say later on that those findings, that there needed to be findings, and those findings needed to be made by the body. So that's my sort of due process concern here.
I don't think there are any provisions that specifically govern the verbiage. It's the matter of the referral or not.
Great. Member Nee?
Yes, I'd like to add to my motion that the director of the department, Mr. Ginsburg, be named as the responsible, as the party responsible in this matter, if the second will accept.
Yes. I don't think that's necessary, but I think it would be pertinent in this case to actually put his name on the document.
It is necessary because you can't have a hearing at ethics affected department. It's an individual.
Speaking to the mic.
It actually is necessary. When ethics takes up the matter, it's not just some vague notion, it's some actual individual, and whether or not it's a department head determines whether it's a Chapter 3 or a Chapter 2 matter under their regs.
Yeah.
Ms. Lee, is that correct?
That is correct.
Okay, great, thanks.
And I would not like this to drag on any further. I want this decided tonight.
Great. I'd like to open it up for, it's been moved in second, so I'd like to open up for public comment.
Thank you, Chair. I'm trying to move this meeting along since... Could you please stop that clock until Mr. Pilpul is going to listen to my public comment?
I'm sorry, you already spoke as a party in support of the complainant, so I don't believe you have an opportunity for public comment at this time. I'm sorry, Mr. Minetshaw.
Chair Grant, can you...
That is true.
Through the chair, make an exception?
That is true. I can't make an exception.
How about if we play strike a deal and I'll hold it to a minute and a half?
I can't. I apologize. Not in this case. You're very persuasive in your support of Mr.
He's wrong. He's wrong. And he should get off the fence.
Mr. Manette, please be seated.
Not complying with an order of determination, Mr. Pilpul, is willful.
Please sit down on the fence, Mr. Minetshaw. I feel it personally.
Is there any more public comment on this case?
Yeah, I guess you have to pardon me for laughing because, I mean, the lady, I mean, I'm remembering the line from 1984 when the guy was being tortured and he said, do it to my girlfriend, my love, and not to me. And that's kind of like what she's saying, just like, take the blame instead of, you know, me telling who my supervisors and my bosses are. So it's almost like she's covering for somebody else. And then it just seemed like she said two different things during her public comment. And then David's comments about they'll bring their opinion from the attorney and it says something different than what they are going to do. I mean, it's kind of like Park and Rec. They do what they want, and they don't care about what the attorneys say or what you say. And they're so arrogant in that they're going to try to tell you what the laws are that you're here to enforce. I mean, I just hopefully that when you put this legislation, this document together, that it's very clear as to more of why these problems occur. These problems, I mean, what these violations are. Just make it very clear, because it looks from me like there was 1, 2, 3, 4, 5, 6, at least like 6 different violations. So it just. I mean, this looks like a 2 or 3 page document as to what they did wrong and why. Thank you.
Thank you. Is there any more public comment on this issue?
Peter Warfield, Executive Director of Library Users Association. I'm not connected with this case, and I'm not very familiar with it at all, but I would like to support the motion and encourage further orations such as Member Nee described himself as making, and including the addendum. I think it is important to mention specific names of specific department heads who have responsibility for what goes on in their department. I think we saw just shameful display of evasiveness and evasion to your questions, particularly with respect to who authored letters that were signed by Ms. Gong. The one that I'm seeing, dated December 19th, 2012, includes things such as, on your page 41, in United States Department of Defense versus Federal Labor Relations Authority 510 U.S. 487, 494-501, parens 1994, parens, quote, Department of Defense, unquote, the United States Supreme Court held that the home addresses of federal employees and so on and so forth. Further down on page 41, in the next paragraph below, which is about in the middle of the page, 3 lines down, see Sheet Metal Workers International, 135 F 3rd at 905. Parens holding that employees have not, quote, waived their privacy rights because their addresses are available from other public sources, unquote, close paren. It goes on to say the U.S. Supreme Court has noted, et cetera, et cetera. If Ms. Gong wrote this on her own or through her own research and knowledge, then I imagine she may be in the wrong job and able to perhaps get a different job. I won't even go on with this next page with all the citations and legal supports. I also heard her say, and maybe it was simply a misspeaking, I heard her say when she said what she was trained to do, that she was trained to reveal the information, particularly names and addresses. Again, she may have misspoken, but that's what I heard her say. Perhaps it needs to check the tape. In any case, all of that, I think, is not necessary at this point, given your direction to find a willful violation, which I think is highly appropriate. I did want to ask about where on the packet the letter requesting Mr. Ginsburg's attendance might be, because I did not see it in the packet.
Madam Clerk, can you address that really quickly? Do you know where it is before I leave?
It's on page,
I'm sorry.
Page 30.
Page 30.
There's an email regarding the notice of the hearing tonight that includes Mr. Ginsburg as one of the recipients.
Thank you. Is there any more public comment on this matter? If not, then I'd like, Madam Clerk, can you take a roll call vote?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
With some reluctance, aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Chair Fisher?
Vice Chair.
I love that. You know, I'm loving this promotion. Every motion.
Vice Chair Fisher?
Aye.
Vice Chair Fisher, aye. And Chair Grant?
Aye.
Chair Grant, aye. You have 8 ayes and 1 no.
Great. So can we just so we're clear, just what we have agreed, the different areas that Member Nee's motion was about. I just want to be clear so we are all on the same page. 67.21E, 67.24G, 67.26, and 67.34.
Yes.
Cool. Okay. So, yes. You have that down, too. So we will draft that letter for the Ethics Commission. Member Sims will definitely work on the verbiage. We will use Member Pilpel's earlier letter, and I'll draft it, and then we can do this together, and then get that to the Ethics Commission.
Okay, so
Thanks.
So when that letter of referral issues, we will send it to whoever and
parties.
send copies to members of the task force at the time that it's being transmitted to the Ethics Commission.
Exactly.
So that we're all on it.
Great. Okay. So at this time, I'd like to take a 10-minute break and come back at, 10 to 7, and start with the complaints. We'll be starting with item number 7. Thank you.
MSNBC a few times.
The money runs out.
Can't remember the issues that it's been.
I'd like to call this meeting back to order. Madam Clerk, can you read the next item on the agenda?
Item number 7, file number 13025, complaint filed by William Clark against the Arts Commission for allegedly failing to provide a written opinion from the city attorney advising the Arts Commission on its current suspension of revocation procedures.
I believe that determination of jurisdiction is by both parties agreed. Is that correct? Can I get a motion?
Second.
Okay, I'd like to move that the motion is passed with...
Public comment.
Oh, that's right. I'm sorry, is there public comment about the jurisdiction? Public comment's closed. In that case, if there's no objection, I'd like to move, pass this motion without objection regarding jurisdiction. I'd like to now invite the complainant up. You have 5 minutes to tell us about your case.
Okay, let me see. Is that the right way?
Oh, yes, sir.
I just want to focus this in on you. There you go. First of all, I'm William Clark. I just want to state something about that that's on page 141, where the city attorney discusses waiver of privilege pursuant to the Evidence Code 912A, because this complaint is going to hinge on this particular Evidence Code statute. He says it may be waived, and this is a copy of the actual law, and Section 912 of the California Evidence Code says that, except as otherwise provided in this section, the right of any person to claim a privilege provided by Section 954, the lawyer-client privilege, and then it goes down further, it says, is waived with respect to a communication protected by the privilege if any holder of the privilege without coercion has disclosed a significant part of the communication. And the communication I'm requesting, I'm claiming, has a significant part of it was released to me by Mr. Lazar when I requested a copy of the email. And so I'm saying that, in effect, the attorney-client privilege was waived by Mr. Lazar when he released the contents of the email that I'm requesting to me. I'd like to go to Mr. Lazar's time frames, because I want you to know they are accurate, and that this whole case started when I requested a hearing to have the Art Commission change its suspension and revocation procedures, because the way they are now, a street art certificate can be suspended or revoked by only 3 votes of the committee, and there are 50 members of the Arts Commission, and I'm asking to have that amended. And in the process of asking for a hearing, Mr. Lazar went and got a city attorney opinion on whether or not the code section 4, 1.04b, applied to the Arts Commission in this case. And as you all know, all you new members, you're here because the city attorney ruled that every board and commission, when voting on any matter, significant matter, is required to have a majority vote of the committee. That's why the old members were removed and the new members were brought in. And in this particular case, on April 6th, by the timeline, on April 8th, 2013, Mr. Lazar informed me and gave me the A, B, C, and D reasons why the city attorney said was refusing to, ruled that charter section doesn't apply to the Arts Commission. Without getting into the details of why he claimed it doesn't, it's really irrelevant to the fact fact that he released that information to me. On April 10th, a few days later, I asked Mr. Lazar to provide me with a copy of the email if he received it, an email or a written copy. He notified me that he on the same day that he wouldn't do that, and he would invoke the attorney-client privilege. And on the same day I notified him again that he had already provided me with the information that was contained in that email, with a substantial amount of it, and he wasn't coerced into doing that, and that because he willingly gave me that information, that he could no longer rely on an attorney-client privilege. And that's the attorney-client privilege waiver that's contained in Section 912A of the California Evidence Code, because I'm claiming that I'm entitled to the email that the city attorney sent to Mr. Lazar, because Mr. Lazar verbally gave me all the information which he claims the city attorney wrote to him in that email regarding my request for that information, A, B, C, and D, which I don't want to take up all my time explaining that to you, but that was the significant portion of the email, and as a result, I'm claiming that he waived his right to attorney-client privilege, and that because of that, I'm entitled to get a copy of that email so I can verify that what he's gave me is correct.
Thank you very much. Is there anyone that wants to offer any facts and evidence in support of Mr. Clark?
Yeah, I just wanted to go over a few things that the city attorney is claiming why they had an attorney-client privilege. The city attorney was saying that in the governing laws dealing with the Street Arts program, there was no language in them giving the Art Commission authority to suspend or revoke a certificate. Now, the problem is that under law, it's clearly understood when an agency is given the right to issue licenses, certificates, that along with that authority to issue it comes the authority to revoke it. And in other words, if I was issuing you a license and I didn't have the authority to revoke it, then after I issued you the license, you could go out and do anything you want, and I wouldn't be able to revoke it from you. So it's clear under the law that the language does not have to be in the ordinance giving the authority to the agency in order for that agency to have that authority. It comes with the authority to issue the license. And the city attorney was using this to cover up the fact that the Board of Supervisors violated the same law when they told the Art Commission that they could, as a matter of fact, when the Board of Supervisors told them and they could have this new rule where only 3 members of the Art Commission could determine whether or not a license was suspended or revoked. The city attorneys claimed they didn't have that authority, yet previous to that, this new law was passed in '94. Previous to that, that's exactly what the Art Commission was doing. After finding someone in violation in the committee, it then went up to the full Art Commission, and the full Art Commission had to adopt it by a majority rule. Now, yet the city attorney was saying because they didn't have this authority, that authority was vested in the Board of Supervisors to give them the authority, and the Board of Supervisors could adopt any method for them to do it. And the method that they gave to the Art Commission was the exact same method that this board, this task force, was completely wiped out because of. They gave them the authority that only 3 members of that Art Commission would rule on the revocation. Instead of going in front of the board, the full commission, it went back to Mr. Lazar. And we have a situation when Mr. Lazar conducted the investigations, and when he determined it was worth putting to trial, he prosecuted the street artist as a representative of the city, and then after the three members ruled against him, Mr. Lazar was the final judge, and I think that's a real chilling effect on street artists' rights.
Thank you very much. Is there anyone else that would like to offer any support or facts and evidence in support of Mr. Clark? If not, then I would like to...
I support this motion for personal reasons, which you know. I've been greatly damaged by this selective prosecution on the part of Howard Lazar.
Is there any more public comment? Public comment's closed.
Support of, it's not public.
Sorry, yes. Support of evidence support of Mr. Clark? No? Then I would like to invite the respondent up. Mr. Lazar, you have 5 minutes to make your case.
Okay, members, I'm Howard Lazar, Street Arts Program Director for the Arts Commission. Mr. Clark very ably took you through my letter. You've all read it, I hope. The only thing I wanted to highlight is that basically the contents of this letter, the way it was written, was dictated to me by members of the City Attorney's Office. And I wrote back to them with, I believe I said, like, I have to add 3 words into it, and they said yes, and that was it. So I don't have a volume of email between the city attorney and me. I just have that one document as far as I can see. So, but this is what was given to me. I have dutifully, rightly or wrongly, I've dutifully stood with the city attorney's advice, working for the city. I think the argument is really, between whatever you decide. If it's against this, then it's between you and the city attorney, and I will do whatever is ordered me to do. But I stand behind the city attorney, number one. So that really is all I have to say. And one line that was in my last dispatch to Bill Clark was the statement that SF Admin Code Section 67.21K, the Public Records Act allows an agency to decline to disclose, quote, records the disclosure of which is exempted or prohibited pursuant to federal or state law, unquote. Disclosure of communications between the Arts Commission and the City Attorney's Office would chill the Arts Commission's ability to discuss candidly issues on which legal advice is sought. Accordingly, the Arts Commission will not waive the attorney-client privilege for any of the subject communications with the City Attorney's Office, nor will it disclose any attorney work product. So, in my discussions with the City Attorney's Office, that caution, if you want to call it that, kept coming up, that disclosure would chill the Arts Commission's ability to discuss candidly issues for which it was seeking legal advice. And that's what this is rested on. So that's all I have to say on it.
Thank you very much. Is there anyone that wants to offer any facts and evidence in support of the respondent? If not, I'd like to open it to the task force members for any questions they might have. Member Nee and then Member Pilpel.
Mr. Lazar, please. The complainant has stated that you've already provided a lot of the information that he had sought, and so that constitutes really a waiver of that attorney-client privilege. How do you respond to that?
That's what he said. Well, that's his opinion. I don't know. I'm sticking with what the city attorney said to me. That's my response.
So you're saying that you're saying that you're not waiving, even though you have provided a lot of the information. Yeah. That doesn't constitute a waiver of the privilege?
I don't know. I'm repeating what the city attorney told me to not disclose. Do not disclose any emails that may have occurred. So if you know, with all respect, if you know more, or you can argue with the city attorney that they're wrong, then I'll disclose what I have. That's my response.
Have you disclosed, have you already, the information that you have already provided to Mr. Clark, do they include the emails?
No.
Member Pilpel, do you have your question?
Yes. So first to Mr. Lazar before you run away too far. So if I understand from the documentation, which I did read and I did absorb, there was communication from Mr. Clark. In response to that, you did consult with the city attorney.
A second time.
Or whatever. You consult regularly. I get that. Specifically on the question of the interplay between the charter and the police code as to revocation and whatever, all that stuff that I don't need to worry about in particular. Is it fair to say that there was, or that there actually, that there was an email or that there is some kind of communication that you're choosing not to release? I mean, is there actually a live controversy here, or is there just some theory that there was communication?
The communication was mainly verbal over the phone, dictated to me. I wrote it down. Okay.
So let's be clear. You created a record based on a verbal communication, but was there actually a memo or an email between you and the city attorney?
Honestly, I don't remember.
So there may or may not have been.
There may not have been.
Okay.
And I just know that my writings, I typed it up, that I probably sent it to the city attorney to look over, and then they said...
So there may have been something that... Okay. I'm just trying to determine whether there is an actual document somewhere here and therefore a live controversy, or if we're just talking in theoretical terms about something that may have been committed to writing based on a phone communication.
The only document that I found related to this matter, when I was going back to the files, was me writing back to the city attorney saying that I had to either add in or change, I don't have the document with me right now, had to add in 3 words into what you've given me. And
then you were just confirming that...
Yeah.
So you don't... Okay, so this may be important. You don't think that there's anything else to disclose, even if we were
No, that's it.
Okay, so that, again, that may be important. Okay, I'm good with you for the moment. Thank you. I actually had a question to Ms. Lee. Here's the question. Since I don't have access to Westlaw and didn't key cite Section 912 of the Evidence Code, what constitutes, in general terms, a significant part of the communication for purpose of waiver of the privilege under that code section? Sorry to put it that way.
No, that's fine. I don't, in terms of actually what constitutes a significant part, I can tell you what does not.
Okay.
And the case that I cited for you in the advice memo, Southern California Gas Company versus Public Utilities Commission, pretty much deals with, it's almost exactly on point, and which is why I advised the task force to pay attention to what actually was disclosed.
In the future, if there's something like that that's really close to on point, you might want to include the decision.
An actual copy?
Yeah, we've done that in the past. It's been a while, but if that's helpful...
That's fine. I included the pertinent language.
Get the part that we need right
here.
Okay, but all right, fair enough.
Just in the interest of not having you read more documentation.
Yeah, exactly.
It's a 20-page opinion. So,
Yeah, thank you.
but
Give that to him next time.
Okay. It's
Right
on.
here, sweetie. Page 138.
So while we're doing that, Member Nee had a quick...
I'm sorry, so I didn't hear the end of the... You said what it wasn't, or you were about to say...
Right. Well, I can read for you what I put in my memo, which is that essentially... It's
the analysis.
a disclosure that shows no more than the fact that a party consulted its counsel and drew its own conclusions is not enough to waive the privilege. And even if it's obvious that the conclusions derive from consultation with an attorney, it's not enough to be a waiver.
Right. I'm not disagreeing with that. What I'm trying to understand is where some further analysis that led to the conclusion is disclosed. How much of that analysis, how much of the analysis needs to be disclosed to constitute an actual knowing or constructive waiver?
Member Pelpel, I don't have the outer parameters of that. However, given the facts that you have before you,
we need not reach that?
Yes.
Okay.
Which is why I directed the task force to study very carefully what exactly did Mr. Lazar or the Arts Commission disclose. He stated he consulted with the city attorney.
Member Nee?
Yes. Ms. Lee, the decision in Southern California Gas versus PUC came in 1990. Since then, we have had Article 1, Section 3 of the Constitution added. That was Prop 59 in 2004. Does that change the equation any, do you think?
Do you have the language for me?
Yeah,
I can tell you that that the Southern California Edison case is still good law.
Okay.
Are there any more questions or concerns? Member Sims, I see you getting ready to ask a question. Or do you want to? Okay. So I would like to invite the respondent up then to offer conclusion or rebuttal. Mr. Lazar, do you have anything you'd like to say in conclusion?
No, thank you for the offer, but I really don't.
Okay.
Thank you.
Mr. Clark.
Yeah, I have a lot to say. First of all, in his timesheet list there, number 5 on April 10, 2013, Mr. Lazar sent an email to me. He said, responded that the city's attorney's emailed advice on this matter is protected by attorney-client privilege and confidential communication. The public is therefore not entitled to view it. He sent me, the city attorney sent him an email. That's what I requested a copy of. Second of all, his statement about the California Records Act. The California Records Act says, except with respect to public records exempt from disclosure by express provisions of law. Now, Section 912 says that if a significant amount of the record is disclosed, then that waiver, that attorney-client is waived. Now, with due regard to what the city attorney has said here, the whole thing that was sent to me from the city attorney, sent to him from the city attorney's office, is contained in, I believe, number 3. I mean, I won't have enough time to read it all. A, Section 4.1.04 of the Charter applies to the expressly enumerated powers assigned to the Arts Commission to Section 5.113, ... B, where the Charter and Prop L, the Street Arts Ordinance are silent as to this, ... C, the Board of Supervisors enacted 2408B, ... on. D, for the reasons above, the Arts Commission's current suspension procedures are consistent with the city attorney. That is the email. He contacted the city attorney for city attorney advice and opinion on whether or not that charter section, which you all are on this task force now because the old members were kicked off, applies to the Arts Commission suspension and revocation process. That whole advice was given in that email. That's what the email is about. Now, I would like to see that specific email. And the fact that Mr. Lazar has told you that this was done over the phone and he took notes is outrageous. outrageous when he put in this that it was an email that he received from the Arts Commission. There's no way that he would be dictated this information over the phone and then write back to me saying that he received an email with this advice. And then when I asked for it, he invoked a waiver, attorney-client waiver, and when I pointed out to you in my complaint that Section 912 of the Evidence Code states that that attorney-client privilege is waived when a significant portion is given without being under arrest, that Section 912A applies.
Thank you very much. Member Oka.
Yes, Mr. Clark, did Mr. Lazar tell you, well, what did Mr. Lazar tell you was discussed? Did he verbalize that to you?
He sent it to me in an email, all those sections under April 8th, 2013. He said, after discussing the matter with the city attorney's office, I responded to Mr. Clark with the following. And then he sent me A, B, C, and D, which was what the city attorney had advised him. And I asked him after that if the city attorney gave him that information in a written opinion or in an email. And he told me he responded in an email to me saying it was given to him in an email. And that's why I'm requesting a copy of that email.
Mr. Lazar, is Mr. Clark's account...
I can't dispute it.
Microphone, please. Microphone, please.
I cannot dispute it. I don't remember the incident that clearly. I have many IDRs that I have to take care of. All I can tell you is, recently in preparation for this hearing, I went to look for documents related to this, and I only found the one that I told you about. So I'd like to produce the other, if there were others, out of the air. But as I say, I think you should say email can also be the city attorney saying, call me, because that frequently happens. Call me, we'll discuss it.
Ms. Lazar, I have a question for you. So,
excuse me.
The complainant has obviously cited Section 91-2A, and Ms. Lee, I need your help on this. But that only has to do with the lawyer-client privilege, which is the fact that you talk to him, or the communication being made. That doesn't waive work product, right?
Correct, it does not.
So unfortunately, any email he sent you is still work product. It's not, it may be, and he literally disclosed to you that the attorney-client communication occurred. He's ready to disclose to you actually what some of the actual product of that communication, but that didn't actually waive the work product. His 91-2A comes to the privilege, the attorney-client privilege, not to the work product doctrine, which is still would not be violated in this case. So I think that's my kind of issue with why here I don't know if there's been a waiver. Because you didn't, that's my issue.
Could I respond to your question?
Yeah, go ahead.
Respectfully, I disagree with you. The attorney-client privilege also relates to any work product that the attorney-client has, and Section 912 specifically states any communication, as I said, except as otherwise provided, the right of any person to claim a provision provided by Section 954, which is the attorney-client privilege, which does relate to also the work, his work, because I have a copy of that ordinance with me. It says, is waived with respect to a communication protected by the privilege. They're claiming that the email that the city attorney sent to Mr. Lazar is protected by the attorney-client privilege, and that's a communication between the two of them. I'm not talking about notes that the work notes that the city attorney may have drafted or wrote were done. I'm not interested in any of that. I'm specifically interested in the communication that was sent from the city attorney to Mr. Lazar.
But wouldn't you agree that communication is the work product produced by the city attorney to his client?
No, absolutely not. That's the work product. The work product is notes if he sits down in his office with and does that. This is a communication where he's given his final advice to the department, and that advice was put in a communication, in an email, and Mr. Lazar disclosed what all that information was to me without being coerced to do it. He willfully gave that information to me.
And the information he gave to you is waived, but the information he did not give to you is not waived.
No,
do you understand what I'm saying?
No, the information he did not. What he's saying is that the communication is protected by the attorney-client privilege. He's not saying the information that's in the document. He's saying the entire email is protected by attorney-client privilege. And I'm saying yes. Normally that's the case.
I think that the issue is, from my standpoint, the information he still has is protected by attorney-client privilege. The information he gave to you is waived, and it's waived forever. You can use that information in any court case, and he cannot no longer claim that information is currently a waiver. The information that the city attorney gave to him is forever work product.
No, it isn't. The communication is the email. That's not the work product. The work product may be notes and things like that. The email that was sent to Mr. Lazar is a communication. And the Section 912A specifically says that the attorney-client privilege is waived with respect to a communication protected by the privilege. Normally, that communication, that email, would be protected by the privilege if he had not released the information willfully to me.
I just want to note that communications between lawyer and client, it's not an either-or. Yeah. They can be attorney-client privilege and work product.
Thank you.
And they frequently are.
Yeah.
Yeah, unless that information is willfully released by either the city attorney's office or the person claiming the privilege, which in this case would be Mr. Lazar. If he willfully releases the information to a third party, and he did it without being coerced to do that, then Section 912A states that he waived that privilege for that communication. And that's the distinction. I'm not asking for something to disclose information or a communication that he hasn't disclosed the information in. I'm saying that the substantial part of that email, that information was willfully disclosed to me. He didn't have to tell me that.
But I think also I'm confused of even if he waived that portion of the community, if what you're saying is true, that there was a waiver, but that doesn't mean, I don't know if 912A, and I don't know about the case law, would then initiate that the rest of that communication is waived as well.
Well, then
I don't know if 912A says whether the communication that was released, once it's released to you or a third party, that particular portion of that communication is now waived, or whether the entire advice and entire communication in its entirety is now waived.
I think that it's pretty clear that it says that the entire communication is what attorney-client privilege cannot be relied on because the substantial portion of the document. I don't know, there may only be 3 or 4 more words in that email.
There may be other things in that email that are stated in there besides what the substantial part is. But what I'm saying is the email that contains the information that was disclosed to me is no longer protected by attorney-client privilege because the information was willingly disclosed to me without being under coercion. And that's why I feel that 912A in this case applies.
Okay.
Madam Chair.
Member Oka?
Mr. Nazar, what Mr. Clark is asserting is that the information in the email you and the city attorney, the email that was sent to you by the city attorney was disclosed to him by you, and was there any other information in that email that you did not disclose to Mr. Clark?
I don't remember, but I doubt that.
So, if you disclose the entire contents of that email, then Mr. Clark is right. That entire email is now public record.
Is there any more? I don't think that was a response, a conclusion. Member Belpel?
At first I thought this was important, and now I'm starting to feel like this is incredibly important and potentially dangerous depending on the outcome. I think public advice from an attorney to a client, in this case a city department, is important to be candid and real and not just, here's our boilerplate, whatever, do with it what you need to. I think at the same time, I think where there's a public matter, it should be out there, and it shouldn't just be, oh, we figured it out, and haha, we're not going to tell you. So maybe this is for us to figure out where that line is. I think the implication, however, is that if you say everything or more attorney-client communications are going to be disclosed, whether they be sunshine-related or Arts Commission-related or whatever, you're going to get less advice in writing, and you're going to get more of these, call me, or let's have a meeting and discuss, and by the way, don't take any notes, because if you take any notes, that is going to be subject to disclosure later on, and we're all going to be in trouble. And so then I don't know who's figuring out what the law means anymore, because nobody can talk. So I don't know that we're necessarily at the extreme, but there are some implications here that are making me incredibly uncomfortable. I guess the question, and Mr. Lazar, you may want to come up on this, the question that Mr. Member Oka just asked, if there is anything else in what it appears to be an email of April 8th or just before, if you can go back and review that email and see if there's anything else there that has any bearing on anything that you wouldn't mind disclosing for whatever reason, and just provide that information to Mr. Clark, then maybe we get out of this without reaching some broad statement about everybody having to do everything one way or never having to do it another way, because I think that, again, could have some dangerous implications. If what you're saying essentially is that, and I don't know who the attorney was, presumably Ms. Gessner or somebody else on the government team, whoever you're consulting with, if they went through and did some analysis of this interplay of 4.104 and the 1.101 and Police Code 22408, and how the licensing and revocation scheme is legit and doesn't warrant a change unless you want to make a policy-based change. If that's what the analysis was and you've essentially provided that analysis, then I'm not sure what else there is. If there is something, you should figure that out. Again, that's why I was trying to figure out at the beginning whether there really was a live controversy here or not. But I'm just, I don't know, maybe I'm making a bigger deal out of it than there is. I just don't want to get to some broad thing where people can't get advice. Because I don't think that serves the public interest broadly well. And you'll have an opportunity. Just hold on.
I was going to say, I think that if you look at 912, and then you also look at D of 912, which says the disclosure and confidence of communication.
Do we have that in front of us?
I don't know if you do or not.
Can you read it out loud?
Yeah. D says the disclosure and confidence of a communication that is protected by a privilege provided by Section 954, which includes the lawyer-client privilege. When disclosure is reasonably necessary for the accomplishment of the purpose for which the lawyer, and then it goes on to the other people, was consulted, is not a waiver of the privilege. So I think under D, he could easily argue and say, the reason I consulted the attorney was to get information so I could then give back to the brothers is the reason why I consulted the attorney. So me giving and disclosing that is not a waiver of that privilege. So I think if you look at 91.2D,
I'm not familiar with that section, but I actually read 912D to be about a third-party disclosure to an expert or a consultant related to a particular matter that's within the scope, and that disclosure to that third party does not constitute a general waiver for the purpose of abrogating the privilege. But
that could too, as well.
And I'm just a guy who hasn't gone to law school.
No, it could. It very well could.
So that's why I say this is all complicated and dangerous territory.
But I also think that it's either protected under attorney-client privilege or it's protected under work product. There's not an exception under work product. So he can't, work product, in my view of reading this, and this is just my view, my analysis, bottom line would prevent this from being disclosed.
Or allow the department to withhold it.
Or allow the department to withhold it.
And I'm inclined to agree, but perhaps to Mr. Clark, if we could get Mr. Lazar to agree to review whatever email, and if there was anything further that hasn't been disclosed, to consider disclosure and put this off, would that?
No, I want a decision tonight.
You want a decision tonight.
And I have two reasons why. One is because I think you're over-exaggerating the danger in this, because first of all, you were referring to all other communications between city attorney and departments. Well, none of those communications were the substantial part of their emails or writings was disclosed to a third party willfully. This specifically has to deal with that. And also Section of the Evidence Code 954, which has to deal with the attorney-lawyer-client. Section 954 says subject to Section 912, and except as otherwise provided in this article, the client, whether or not a party, has a privilege to refuse to disclose and to prevent another from disclosing a confidential communication between client and lawyer if the privilege is claimed by A, the holder of the privilege, B, a person who is authorized to claim the privilege by the holder of the privilege, or C, the person who was the lawyer at the time of the confidential communication. But such person may not claim the privilege if there is no holder of the privilege in existence, blah, 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 blah. So what I'm saying is Section 954 specifically relates back to Section 912, saying the attorney-client privileges is subject to 912, and I think Mr. Pilpo is correct in his interpretation of Section D, that Section D means if these guys, city attorney and Howard have to go to a third party and ask for some advice or some further opinion, that the fact that they went to a third party who wasn't the city attorney and that individual gave them some information, then that doesn't amount to a waiver of the privilege.
Thank you very much.
I know this is weird.
No, it's not. It's very...
But it is explicit. All I have to say in the end is 912 is explicit. It simply says that if a significant part of the communication, in this case it's the email, was released willingly, which it was, there's no doubt about that, that means that you can't refuse to release the entire communication, which is the email, based on the attorney-client privilege. And I think that, some people are going to make this more complicated than it is. This is specific to this particular case. Okay. All other communications between the city attorney and the department are still attorney-client privilege.
Okay.
Thank you very much.
All right.
At this time, then, I would like to know if there is a motion to find a violation, the Sunshine Ordinance.
Also move.
What's your motion?
Oh, sorry. That we find that there was...
Is it these right here? Is he originally?
hold on a second. No, I think... I don't know how I get to 912A. Maybe I need some help in crafting that, but I guess I'm convinced now that without coercion that there was disclosure of a significant part of the communication, and therefore the privilege which was held by the Arts Commission was waived, and the entirety of the communication, to the extent that there's anything further in the communication, should have been disclosed. So if someone can help me figure out which section was violated that gets to 912A ultimately, maybe Ms. Lee, that would help, because that's my motion. And it would ultimately order the department within 5 days to disclose the rest of the email if there was anything further to disclose. Again, can someone help me with the code section?
Are you saying that because you feel that there was a waiver, then the record is public?
That the
record is public?
The rest of the communication, if there was anything further to it, yes.
That's public.
Yes.
So that's, I'm trying to refocus what I believe what you just told me.
Okay. I'm sorry, it's late and I'm losing it.
No, I understand. I understand what you're saying is that you want to make a motion that there was a waiver.
Yes.
Okay.
That it appears, based on what we've been told, that there was disclosure of a significant part of the communication without coercion, and under 912A of the Evidence Code, that the privilege was waived, and therefore the rest of the attorney-client communication should be disclosed as a public record. I'm just not sure where in Sunshine that is, because I think somehow you get from 67.21 or 24 to 6254K that then gets you into 954 and 912A. So that's why I'm not sure how to structure the violation. Do you understand what I'm saying?
I do, and I don't think that anything more need be said.
Well, isn't it a violation of not releasing public information?
Yeah, but I'm not sure how we find. It's not really a violation of 912A. It's a violation of something in Sunshine or Public Records based on a waiver under 912A, but I'm not sure that we have direct authority under 912A only to get there through 954, through 6254K, through something in Sunshine.
Well, it would be 67.21 because it would have to do with the process that I was entitled to getting that information within the 10-day period.
Fine, 67.21A. Okay. With the explanation, whatever.
Right, with
that I
your
just gave.
explanation.
All right.
Is there a second?
67.21A. That gets to 912A, et cetera.
Is there a second?
Anybody- Did I?
I second it.
It's been moved and seconded to find a violation, 67.21A.
Sure.
Okay. Would like to open it up for public comment on this issue.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I actually do think this is a very, very important issue. And no, we're not looking at a broad thing where everything an attorney writes down, which is actually work product, but then ultimately uses in the memo to advise a client. I have repeatedly gone before various boards and commissions who say to the public, this was advice from the city attorney. And they say, in some cases, this was a legal opinion of the city attorney. And they need to understand that a legal opinion from the city attorney's office has a very lengthy requirement that they must meet to call it a legal opinion. Otherwise, it's just a memorandum. Okay? But there is nothing that prevents these folks from cherry-picking what they want out of the advice they get and leaving out other caveats that the attorney included. In other words, they say, well, you could argue A, B, C, but they could come back very well and say that A doesn't apply for this reason, and B doesn't apply for this reason, and C doesn't apply for this reason, and all the person wants to do is keep from giving you what they have. And so they ignore the fact that there's an alternate argument and simply present the city attorney's opinion as being A, B, C. And the bottom line is they mischaracterize, and they actually put the city attorney's office in the position of having their advice misrepresented. They're not there in many cases, and as a result may not realize that what these bodies are doing, or members of the bodies are doing, is actually bastardizing the opinion they were given. In this particular case, I think it's critical because we got substantial information that was sent by the client to the Clark brothers saying the city attorney said this and this and this and this. And I think Mr. Clark was very, very good at saying it's kind of hard to believe that this detailed legal opinion material would have been something Mr. Lazard chatted about on the phone and made notes about. I just can't see that as being reasonable. And I have to believe that there was an email sent. He does the, I don't know, whatever. I think by this point in time he would have gone and seen if there was an email, or maybe does know there's an email. And at some point it becomes a consideration of what was presented by this board or commission in justifying their action, how much of it was actually supported by this memo, and how much of it is questionable under the memo.
Thank you. Is there any more public comment on this particular issue? If not, public comment's closed. I'd like to take a roll call vote, Madam Clerk.
Member Ernie?
No.
Nee, no. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
No.
Sims, no. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Fisher, no. And Chair Grant?
No.
Chair Grant, no. Yeah, 5 noes and 4 ayes.
Great.
Could I just make a quick
Member
comment
Pilpel?
to Mr. Lazar? notwithstanding the fact that the motion failed, could you consider, and we're certainly not directing you to do this, consider asking the city attorney whether they wish to publish the advice as a written opinion to you, as a public opinion? Because it seems that it bears on a significant matter of public interest as to how your licensing and revocation process works, and they may ultimately decide to make it a public opinion. That might be another route to resolve this.
I'm not averse to that.
You may want to consider that,
Yeah.
discuss it amongst your people.
Okay.
Just a thought. Thank you.
Thank you.
Thank you. Madam Clerk, can you go to the next item on the agenda, please?
Item number 8, file number 13026, complaint filed by Ray Hartz Jr. against Angela Cavello, clerk of the board, for allegedly violating Sunshine Ordinance 6716, minutes thereby censoring and abridging public comment, violating 6715 public testimony.
Okay. I believe jurisdiction is accepted by both parties? Yes. Great. Can I get a motion to accept jurisdiction? Yeah, I do.
I move that we accept jurisdiction.
Can I get a second?
Seconded.
Oh, yeah.
The motion is, public comment about the jurisdiction?
I would call agree.
Is there any more public comment on jurisdiction?
None.
Hearing none, then I pass this motion without objection, and would like to invite the respondent up. The complainant up. Sorry, it's getting late. Okay, and take a deep breath. The complainant up. You have 5 minutes. Thank you.
Thank you. Members of the task force, I'm going to give you some good news about this. And despite the fact, if you read through all the materials you have, it sounds like this is an issue about the 150-word summaries. It is not. It is only tangentially related. The only thing that really applies is if you go to the memo by Ms. Lee, the attachments actually quotes from the Sunshine Ordinance. And it says, Section 67.16, minutes. The clerk or secretary of each board and commission enumerated in the charter shall record the minutes for each regular and special meeting of the board or commission, and it goes on to start listing. If you go down to about the last 3 or 4 lines, it says, the names of the the names of the members and the names and titles were applicable of any person attending any closed session, and then it goes on, a list of those members of the public who spoke on each matter if the speakers identified themselves, whether such speakers supported or opposed the matter, a brief summary of each person's statement during the public comment period for each agenda item. I think that's pretty clear. And if you go to the first or any of the examples, I'm looking in particular at the one, and I don't know what your page is, it's meeting minutes for April 11th of this year. And it lists the bottom page 127. And at the top of the page, it lists public comment. Abdallah Magad expressed various concerns. Darren Smith expressed concerns relating to a standard of living for the blind community. James Chafee expressed concerns relating to the San Francisco Public Library. Now, if you go back and look at the actual wording of the minutes requirement, it says I'm supposed to list the name, which I'll give them they did, and then you're supposed to go in and say what they spoke about, whether they were for or against it, and give a brief summary of what they said, none of which is in here. None of it. And basically what's being done is they are abridging public comment. Because in the official record, they are saying this person just got up and said an innocuous thing. I've had them get up and Mr. Hartz got up and spoke about his concerns. How does that reflect what I said? In what way? How would any member of the public, looking at the official record of the meeting of the Board of Supervisors, be able to tell whether or not they may perhaps want to go to SFG TV and actually listen to the full comment? They wouldn't have any idea. And as a result, what is essentially being done, whether it was intended or not, is a actual de facto abridgment of public comment. And also, I would argue, a restriction of public comment. You know, in relation to the 150-word summaries, one of the reasons I did bring forth the idea of the 150-word summaries was I was tired of seeing my public comment, which if you've gone to a Board of Supervisors meeting, they start their meeting at 2, and it's a free-floating agenda. Public comment could be at 2:30, it could be at 6:30. So if you want to talk to this Board of Supervisors, you basically have to just plan the whole day. They don't really want the public comment, and they make it very clear by the fact that when the public comment comes up, some of them leave the room, the rest go on their Blackberries or their computer. You know, in the last Board of Supervisors meetings, the president of the board and 2 of the commissioners were standing up at the podium having a discussion, and it was obviously a very funny discussion because they were all laughing. None of them paying any attention to the members of the public. So what I'm saying is, I really don't think this is probably Ms. Cavillo who's doing this directly. I think she has been given direction by the board to minimize what gets into the official record. And I'll give you the perfect example. We fought over and over and over again to get public comment in the Library Commission meetings because we didn't want them to later be able to come back and say, oh, nobody ever said anything about this. And that's what this does. It simply gives them plausible deniability by saying, oh, well, nobody ever brought up this specific issue, and that is a problem.
Thank you. Hold on, let me see. Is there anyone here that wants to offer any evidence or facts in support of Mr. Hart's? If not, then can I invite? Okay, I'd like to invite up representative for Ms. Cavello, Clerk's Office.
Good evening, guys.
Hi.
Rick Caldera, Legislative Deputy for the Board of Supervisors, and I'm here speaking on behalf of Ms. Cavillo. We initially misunderstood...
What was your name? Sorry.
Rick Caldera.
Thank you, Rick Caldera.
Yeah.
You said it so fast.
We initially misunderstood Ms. Hart's complaint as we felt it was relative to the 150-word summary. So I went running downstairs to go talk to Ms. Cavillo to create a different response for tonight. After a brief discussion with Hart's, we feel that in accordance with the specifics of this complaint, the clerk of the board still feels that we do provide minutes of the Board of Supervisors that do conform to the Admin Code, Section 6716. Specifically, we're required to indicate the names and titles where applicable, a list of those members of the public who spoke on each matter, if the speakers identified themselves, whether such speakers supported or opposed the matter, and a brief summary of each person's statement during the public comment period. We understand, pursuant to past hearings, that there are some disagreement from the task force members that we do not conform. However, we take minutes to protect the speakers to ensure that we are not misrepresenting their public comments. We would like to mention that there are some public testimony that is completely incomprehensible. In those instances, we do indicate they express various concerns. I would encourage each of you to be a clerk for a meeting and trying to understand and articulate what these individuals actually are saying. Sometimes it's very difficult. Therefore, for future, we would strongly encourage the public speakers to be as clear as possible to ensure that the clerks may identify whether comments are opposed or in support of items. And finally, as Mr. Hart does provide on many occasions, public speakers may provide the 150-word summaries pursuant to 6716 to include, which will be appended to the minutes of the meeting. Thank you.
Thank you. Is there anyone here that wants to offer any support for Mr.
What was your
Ray.
last Rick?
I just
What was
said
your
Rick.
last name?
Caldera.
Caldera.
Caldera. I want to say Rick. I'm
Think
going
of
to say
a
Rick.
volcano, that's a
Caldera.
Caldera.
That's why I'm so red.
Yeah. Okay. If there's anyone here that offer any support, facts and evidence, additional information, if not, then I would like to open up to the task force for any questions you might have. Mr. David, you had a question?
Yeah, Mr. Caldera, please. So I was just, isn't public comment at the Board of Supervisors always the next to last thing on the agenda?
It's just before the without reference to committee.
Without reference to committee. I mean,
Correct.
so I guess I'm a little bit confused because so Mr. Hartz, please come up. I'll ask Mr. Hartz the question. So, do you agree that it's always right before without reference to committee? That's when public comment is?
Normally, it's, yes, way at the end of the agenda.
Yeah, so your comment that it is sometimes at 2:30 and sometimes at 5:30, does that have more to do with how long the actual agenda is as opposed to when they are taking it as in order of the agenda?
No, it has to do with their openness and willingness to have the public participate in the meeting. In February, in 2 different meetings in the month of February alone, public comment was held on one day at 2:30. The board meeting started at 2, it was at 2:30, and several people came in going, they already had public comment? And then at a meeting 2 weeks later, public comment was at 6:30. So basically, what they say is, if you really want to talk to us as the Board of Supervisors, plan the whole day.
But I guess my question is, what time did each Board of Supervisor session end on each one of those days?
It's all over the place. It could, there was one that was 8:30, there was one that was 9:30, there was one at 6:30. I guess maybe, am I misunderstanding your question?
I think what I'm trying to say is, right, in our minutes, we say that we take public comment as close to 5 o'clock as possible, right? With the Board of Supervisors, it's my understanding that it is the next to last thing on their agenda.
Right.
So the time can flow the time can shift depending on how long their agenda is.
And I would say it shifts to the point of being arbitrary.
Okay, thank you. That's all I wanted to get.
Member Pelpel or Member Nate, do you have something? No. Okay. Member Pelpel?
So, to Mr. Hartz, I guess, I understand the nature of your complaint. The way that public comment is summarized, whether it's at the board or other boards and commissions or committees, can vary. Do you agree that there are instances where comments are difficult to understand and need to be summarized in some fashion and may end up as male speaker express various concerns? Do you acknowledge that?
Yes. In fact, I told Mr. Caldera before the hearing started that I understood, because he said, he mentioned a couple people I'm familiar with and said, it's very hard to figure out what they're talking about, yada, yada, yada. But look at the lists that I have provided you. Every comment. So are they saying every single person who gets up, they can't figure out what they're talking about or whether they're for or against it, or basically summarize anything about what they say? It's just a list of names. And often, it just says various comments.
Okay, but no, I disagree. If you go to the specific...
Does any of them summarize?
I'm sorry. The specific citation that you gave us, page 186 of the packet, from the meeting of March 5th, that was printed on April 11th, that it appears that there were a number of speakers expressing concerns related to taxi services and mandates. At least one of these...
For or against?
It doesn't say, but it was public comment. It wasn't on a particular matter, so there wasn't legislation that they were speaking.
You just said it was on a specific matter.
No.
The taxi commission, or the taxi, whatever it was.
I'm sorry. Maybe if you look at the particular page that I mentioned.
What's the first name? Abdullah?
Yeah, but he's usually the first speaker. Okay. Okay, it's page 186 of the packet.
Yes.
Starting with 1, 2, 3, 4, 5, 6, 7. Mark Rugger expressed concerns relating to taxi services and mandates. And there were 4 other speakers at that particular meeting, and one above it, male speaker, related to taxi services and mandates. It appears to me that there were some folks that, whether they were taxi drivers or taxi passengers or taxi people, that were concerned about taxi services and mandates and used the opportunity for general public comment to say that directly to the board.
Were they for or against it?
It doesn't say, but
that's what the law says it's supposed to say.
Where it's on specific legislation that you're for or against, there was no specific legislation that was being discussed. This was general public comment for which
I would ask the members of the task force.
I'm sorry,
I'm responding to your
finished.
question.
No, I'm not finished.
Well, we'll get to the question. You just keep rambling.
Yeah, I'm sorry, it's late, and, you brought a complaint, so I'm trying to address it here. I asked you about individuals expressing various concerns, and you admitted that there are instances where that makes sense. As to your concern about abridging constitutional rights to free speech, the way I analyze the thing, you have the right to free speech which you exercise.
Is there a question here somewhere?
Yes. Do you agree that the constitutional right to free speech gives you an opportunity to speak, but that speech is limited in time and subject to other kinds of requirements?
No, I do not.
You think that you can speak wherever you want?
The Supreme Court has ruled that the government publishing what you say in an official document is protected by your free speech rights, because otherwise the government is allowed to change what you say, mischaracterize what you say, restrict what you say. And all of the law says that if you get up and say something, they don't have the right to simply reduce it to nothing.
I don't believe it's being reduced to nothing. And do you have a particular citation that you're offering us in support of that assertion?
Okay, I'm talking to the task force.
I asked you a question.
Do I have a specific citation? No, except for the Sunshine Ordinance, which clearly says that there are 4 requirements.
Yes,
that
I'm
you
aware of
identify
that.
the person,
And they've
you
done
talk
that.
about what it is the issue is,
And they've
whether
done
they're
that.
for or against it, and a brief summary of what they said.
And they've done all of those things.
No, they have not.
Well, then there'll be some debate on the task force.
Yeah.
That's my position. Thank you.
Is there any other member of the task force wants to say anything?
Mr.
Member Ogot wants
I'm
to
sorry.
respond. And then Member Sims.
I am not here to debate Member Pilpel's position or not. I have attended several Board of Supervisors meetings, and I know exactly what Mr. Hart means, because when people speak, you read the summary, you don't know what they spoke about, or whether they were for or against anything. None of that exists in the summary. So, how is what Member Pilpel said supposed to make sense? Doesn't to me.
Member Sims?
This is, I guess, this is very, can Mr. Rick, Mr. Caldera? It's Rick.
Yes.
So, I was confused about kind of how the agenda is done. So, when someone makes public comment after an official, they make public comment after each agenda item, correct?
No.
No. Okay.
At the Board of Supervisors, public comment happens at committee. All of the work at the Board of Supervisors is done in committee.
Okay.
So items get introduced at the board, and then they get referred to various committees.
Okay.
And that's where the public comment happens, is at the committee levels.
There's some limited public comment at the board on certain appeals and other.
Okay.
Oh, yeah, it appeals, and certain specific public hearings that happen at board.
So there's a just general public comment section.
There's a general public comment at the board.
At the board, okay. And that is generally
Or committee.
at the end of the business, and this is the excerpts we're seeing from those people who made public comment.
Correct.
Which really isn't that much, I mean, considering.
It's not really that, what did you say?
I mean, considering that it's a Board of Supervisors meeting, and I'm seeing public comment from 15 people, like, as much as we see public comment, to me, that you got an easy street, buddy. Like you really do. You've got easy street. So my concern here.
Caldera. That's the Caldera
Caldera, Mr. Caldera.
I'm blessed,
right?
yes.
So my concern is, I get your brief summary. You can only give so much of a summary of what the people are saying. And I understand your concern is you don't want to
represent
what they're saying.
Correct.
But if some individuals are getting up and they're saying, I'm opposed to agenda item this, or they're saying, I disagree with this.
That's not during general public comment. They're actually not allowed to speak during general public comment on items that have already been acted upon or had a hearing in committee.
Okay, so they're talking about just general items.
Correct.
So, but they're talking about the taxi industry and everything else.
Mm-hmm.
So is there some type of, I don't know, do you know what Ms. Cavillo is willing, is there more she's willing to do, or is this, from your representation, this is about as much as we can do when it comes to public comment?
67.16 indicates a brief summary. And Ms. Calvillo is under the impression that she is providing you with a brief summary.
Okay.
Member David.
So I don't know if anyone else on the task force has ever served as a legislative aide besides me, and so actually this is something that I know just a little bit about. So what Mr. Caldera said, which might have kind of gone past people fairly quickly, is that most of the work and the substantive public comment is done in commissions. At the committee meetings. And so when the Board of Supervisors takes votes, they do not take public comment before, during, or after, except on appeals, as Mr. Pilpel said, in very, very limited situations. So this is general public comment at the end of a meeting on nothing, on no legislation, nothing that has to do with what was actually talked about at that Board of Supervisors meeting. So I'm not expressing an opinion as to whether the way that Ms. Cavallo is doing this is correct or incorrect. I just want to straighten that out, that it's a very different process than what we have here.
I think it's very important to point out, though, during public comment or actually the public hearings, if it's for an appeal, there's specifics that states that, there may be 20 people that spoke in support of that appeal, or there's 20 people that spoke in opposition to that appeal. We do indicate that for those public hearings that happen at the full board meeting. And during the committee meetings, the committee clerks actually do state whether or not on the specific items that they were heard in committee and the various people that spoke, and whether they spoke in support, they spoke in opposition, or they spoke neither in support or opposition to the matter.
Got it, okay. Member Washburn? Then I'll come back to you.
This has been very informative for me, so I appreciate the matter being before us. And I do understand in some cases it would be really impossible to give a summary. If you don't really know what the person is saying and you can't pull a message out of it. But I think in some of these instances, it seems to me that a summary could be made, and could be made very succinctly, and could be somewhat informative. And I think what we have here, I wouldn't characterize any of these as summaries. I would say they're just a listing of the topic that was discussed. So I would think it would be helpful to anybody reading these, if at all possible, in 2-3 lines at most, give the main point that was being made. Otherwise, why have the public comment if the supervisors aren't really paying attention? What are we doing here? And minutes are a record of what happened. And I think if somebody has taken the time to come and in some cases thoughtfully prepare some remarks, then those should be captured of course, there's the videotape and so forth, but I think these could be much better, probably with not a great deal of effort. And in some cases where it's impossible, yeah, I think you don't want to misrepresent what somebody says. And you can't make sense out of nonsense in some cases. But in other cases, you can, I think, in a, fairly readily, you know what the person's trying to say in some cases. So why not just summarize it? I think that would be very much in keeping with the spirit of the ordinance.
And I can certainly relay those back to Ms. Calvillo, and I do encourage each and every one of you to clerk a meeting. You can come sit next to me any day.
Oh, when's your next meeting?
It'll be on the 19th.
They meet on Tuesdays.
Tuesday.
Actually, we're not meeting next Tuesday. It's a holiday on Monday, so we'll meet on November 19th.
This is the 2 o'clock
Board meeting.
The one that you
Yes.
Member Popo.
I'm sorry I'm losing it. I just wanted to clarify 2 points, Rick, while you're still up there. In addition to public hearings on appeals, the general public comment includes comments on the with adoption without reference calendar.
Correct.
And in the instance, and I have spoken under general public comment about resolutions and motions on that for adoption without committee reference calendar. In those instances, the minutes would reflect that an individual spoke either in support or in opposition to a particular matter where there was a particular matter attached to their testimony.
You're correct.
And for anyone here who has not been to a Board of Soups meeting recently, you should either go or watch it on SFG TV, and if you can figure out how to better summarize Abdullah or Walter's, conveying views via song, or the religious guy expressing that God will smite you down because of I'm not sure why, or the number of other regular individuals that use their opportunity to speak to so speak, feel free. Mr. Chafee, for example, has the opportunity and regularly expresses views about the library and its conduct, and I think the summary that says James Chafee expressed various concerns about the SF Public Library is pretty much right on. And we can expend a lot more effort trying to summarize the remarks of individuals. To what end, I'm not sure. I think if people want to see what people exactly said, they should watch the video, and so we have that as a record. This is merely a written record that's summarizing the fact that they spoke, and in my view, it complies with 67.16. Thank you.
Are there any more comments from the members of the task force? Not. Yes, Mr. Oka.
Mr. Caldero.
Yes.
How much more work would it be to have you or Angela summarize in 150 words or less what was said during general public comment?
Pursuant to 67.16, the public speaker can submit 150 words, but we will summarize in the manner that we've been summarizing, and that's what's in front of you today.
Is that included in the text of the minutes?
It's included in the addendum, but that's not the item that's before you.
It's not the issue for Mr. Hartz this time.
The summary, not the 150-word statement, but the summary created by the clerk of the board is included in the body of the minutes and is above the line, if you will.
The summary that she's crafted.
And the concerns generally mean someone is against something. So when I'm reading all of these things saying about all the concerns against specific being taxi commissioner or something like that, that we can gather that is against, or do we need...
You could.
Or they could be for.
Or it
We have
could be
no idea.
for.
You could. I mean, there are certain
Concerns?
individuals that are coming in. We have people that are, speaking relating to like the Lyft service versus the taxi service. And
Oh,
so
so
we
we can't
generalize, what is it that they're talking about? What is that general topic that they are just
Okay.
speaking about?
And the people that you just said, just one last thing, the Abdullah, I'm not familiar with them, but various concerns, that means that it was quite difficult
They were all over the place.
Cool.
I mean, sometimes it's in Arabic and English, and I'm not really sure where
They're going.
Yeah.
Okay.
Yeah, maybe it's about the picture that he shows sometimes. I honestly don't know.
Oh, okay.
Yeah, sometimes it's, he'll submit a letter that we submit to each of the supervisors, but it's not the 150 words, and,
okay.
but that may have been one of 20 things that he actually talked about during that.
Got it.
It varies.
Member Sims?
And I was going to say, obviously there are, in many ways I'm saying, I think, I wish there could be more, but, in this instant case, I think that the statute is specific, but when the situation does not lead itself to matching the statute's specificness, I think you then have a problem with what the clerk of the Board of Supervisors can do. If they're not being clear of what, in this particular instance, this public comment regarding whether they're opposed or not opposed because there's not a topic that they're talking about, I think it's okay to say express. I think their summary is brief. Yes, it's a brief summary. Now, will it meet everyone's standards? No, but I don't know if the ordinance requires more than brief, and then I guess it's our determination if is this too brief or is this meet the requirements.
Meet the requirements.
I think here they probably tend to meet the requirements for myself in the fact that if you don't like the summary,
Submit.
you should submit. I would submit. But I don't think this leads to the pushes me over the edge.
Member Sims expressed concern regarding the statute. That's what you just said.
Yeah.
I mean, I'm being facetious, but there was a lot of content there, and that summary could have gone in just like that.
Yeah.
This is a problem. 150-word summary, yes, but I still think they could do better. I really do.
If there's no more comments, I'd like to ask Rick if you'd like to come up, if you have any concluding statement or anything you want to say.
No, I have nothing. Thank you, though.
Great. Okay. Mr. Hartz?
Members of the task force, believe me, I understand the whole discussion that just went on. And Mr. Caldera and I have had the discussion, and he says, well, when Abdullah gets up and does this, or Walter gets up and sings, it's difficult to do this. But I see you going in the other extreme and saying, because we have 3 or 4 people who get up and it's difficult to summarize what they say, we won't summarize what anybody says. We'll just treat everybody the same. And what does that lead the public to believe? Every single person who gets up at public comment gets up and says stuff that isn't even worth putting down. I believe that that's the intention of doing it this way. Just like it is the intention of the Board of Supervisors to discourage public participation and comment at their meetings by making it an arbitrary time when the public is given an opportunity to speak. They basically, at the time of public comment, some of them get up and leave the chamber to go to the bathroom, always making sure there's enough to maintain a quorum. They sit off to the side and have conversations with the staff. Basically, it sends a very loud, clear message to the public: we really don't give a shit what you have to say. And it is all done with the intention of discouraging public participation because they just don't want to be bothered. And in this particular case, what they particularly do not want is someone getting into the minutes something they don't want people to hear. Mr. Chafee's comments are typically about the Friends of the Library and how the fact that there's no oversight for all those millions of dollars. Is that impossible to summarize ever? Or is it simply, we will pick one phrase for Mr. Chafee, and every time he comes up, which is every Board of Supervisors meetings, we will use the same phrase. And if someone as the public is reviewing these minutes, they're going to just assume, well, I guess Mr. Chafee got up and said the same exact thing every single time, every single week for 30 years.
Pretty close.
Basically, what I'm saying is, fine, you want to say that there are certain circumstances where it's difficult or almost impossible to summarize what the person's saying. That's fine. I'm willing to go to the halfway point. What I'm not willing to do is say that because you can cite a few examples where it's difficult to do so, that it's impossible to do so for anyone. And that's the argument that they're putting forward. They're simply saying, and I'm asking you, if you really care enough about something that you want to speak to the Board of Supervisors of this city, you're elected representatives of city government, and you get up and take the time to go and say that, do you want your comments represented in this totally meaningless manner?
50 thing. Is there, you've done both. Is there a motion to find a violation of the Sunshine Ordinance? Okay. If there's no motion, I'd like to find a violation. I'd like to open it up to public comment. Ms. Natter?
I think there's several things. I think the minutes are supposed to be more of a document so that it's recorded like 100 years from now. So 100 years from now, you can have a clear understanding of basically what's happening. I think my other thing too is for or against an issue, I could be concerned about an issue, but I could have two opposing ideas and express both of those ideas. I could be for a position and I can be against that position for different reasons, and I could come there and express those. But it's neither or. Now the other thing too is the closed caption. I mean, to me, the solution to this is very simple. They get a copy of the closed caption, they dissect it up and chop it up like this person said this person said this, just indent in between what each other person says. And the information is all there. And they have enough time to do it regarding, like if somebody does an information request regarding the minutes, I mean, they could have up to 10 days to get them that information. So they have the time to do it. The other thing too is this intangible thing. Abdullah, he's not all untangible. I mean, you can understand some of what he's saying. And then if you look at the person who's singing, you can understand what he's saying. And then even the lady that gets up and speaks with triple dyslexia, you can't follow a clear idea of what she's saying, but you can understand what the individual words are. So I just think that we need a little bit more information that's already coming through on the closed caption. And the other part of it is we need the minutes instead of going to some type of electrical media, is because those records are supposed to be preserved in case of an earthquake or some type of major national disaster. So there needs to be some type of clear paper documentation as to a brief summary of what's supposed to be said, because, I mean, the people who are doing closed caption, they get it relatively close as to what each individual says. I mean, why can't they do a better job or standard of this?
Thank you. Is there any more public comment on this matter?
Thank you for bringing triple deficit dyslexia to light. It's actually very serious.
I'm Peter Warfield, Executive Director of Library Users Association. I'm very dismayed by this discussion, particularly by one of your members who I think ought to know better, and perhaps you need to bring a dictionary. The Law says at 67.16, what is required by the minutes, and your page 183 has it about two-thirds of the way down. A list of those members of the public who spoke on each matter if the speakers identified themselves, whether such speakers supported or opposed the matter, a brief summary. Summary. What is a summary? I don't believe that what I see here in the examples provided by Mr. Hartz is a summary. It is perhaps a topic listing, but a topic listing is not a summary. James Chafee, on your page 186, expressed concerns relating to the San Francisco Public Library. Peter Warfield expressed concerns relating to the San Francisco Public Library. Page 187, James Chafee expressed concerns relating to the San Francisco Public Library. Page 188, James Chafee expressed concerns relating to the SF Public Library. Peter Warfield expressed concerns relating to the SF Public Library. Those are topic listings, not summaries. And Mr. Caldera is smearing the public when he says, oh, you can't understand what they're saying. He's a very smart guy. But you don't have to be that smart to understand some of the people who are talking here. And if there is an occasional one or another that he doesn't get it, or somebody else doesn't get it, they can listen to the tapes. They can look at the unfortunate, dysfunctional caption notes. Chafee, in a recent book put out by the legendary Sandy Berman, was mentioned 5 times in the index, including a portion of an article he wrote. My name, 4 times. No other individual was mentioned in that book more than 3 times, except the author himself. And he included also for me an essay that I had written, which he had published previously. Chafee and Warfield are not inarticulate. And I think you know that from direct experience, as well as go listen to some of those comments that are made in public. And these are not meeting the requirement to summarize. And Mr. Caldera knows it perfectly well, and so does your member Oka, and so does anybody who will listen to the comments that are made in public at the supervisors.
Thank you very much. Is there any more public comment? If not, public comment is closed. Since there was no motion to find a violation, I'm going to declare this matter concluded, and let's move on to the next item on the agenda.
Is it possible to make a motion at this point?
No.
Why not?
Actually, you can.
Can he?
Yeah.
Is it, Celia?
Through the chair. I mean, I wanted to say it before you concluded, but...
Oh, because, well, we had asked for a motion and then no one had put it up.
You haven't moved on. I think it's timely. I think.
You can move.
Yeah.
You can move.
Go ahead.
There's one piece, I want to make a motion on 6716, except it says, the language refers to speakers supporting or opposing the matter. In other words, not general comment. It's comment based on agenda items. And because the Board of Supervisors don't allow you to make comments on the matters, except for rare circumstances, I'm having a hard time getting to the correct area to make a motion on. Perhaps someone can help me out here. Maybe 6715?
Because does the public, just let me clarify, in the Board of Supervisor meetings, on specific, during the committee, that is when they are allowed to make public comment and be more specific. So it is just during general public comment that is the way that Angela has chosen to not, to summarize. This is her way of summarizing.
Mr. Hartz?
May I respond to that?
I think where there's a specific matter and a member speaks, and a member of the public speaks in support or in opposition to that particular matter, the minutes so reflect. Where there's general public comment and they're isn't a particular matter that they're speaking in support or in opposition
And those
to,
4 points, those
then it's
4
those
requirements
concerns.
don't exist. That's
Right.
And perhaps, Mr. Hartz, you can address that.
Thank you. Basically, if you look at the minutes, which I have done because I knew this issue might come up, they do pretty much the same thing. Ray Hartz got up and spoke for. Mary got up and spoke against. And as far as the summary goes, they don't really include that. And I think that's a real problem, and I think one of the good examples you could do is yesterday's election, where all of these people are coming out for the Props B and C and raising the height limits on the waterfront, and the citizens came out and said, hell no. What they don't want in these summaries is they don't want anything specific where the person came out and said, you know, what you're doing is unlawful. What you're doing is illegal. Stop it. Start it, or whatever. And in the hearings, individual hearings, when it comes to the public comment on the matter, they do nothing but list the name and say whether, they occasionally say whether they were for or against the matter, but go no further than that. So it's really not much different.
Thank you. Member Nee? Oh, member. Okay.
I was just going to say that I almost made a motion earlier, but I ran into the same issue, Member Highland, that you did, thinking that this really pertained more to specific agenda items. But I still think that a balance could be struck here. I hope maybe we'll see a case that pertains to public comment on a specific item. That would be a good one to have here. We could, really make our views known. But, in this instance, I still think, although I'm not going to make a motion, I would hope that the brief summary would be interpreted to mean a capturing of the essence of what was said, not just the topic. And it may be very difficult to do in some cases, in which case, your summary could be very vague because it has to be. But in other cases, I'm talking about several clauses, a sentence, or, 2 lines, 2 or 3 lines. But, I would be pleased to see that. And so I want to send Mr. Caldera off with my wishes. I don't know if other members may feel the same way.
Member Nee?
If there is to be a motion, respectfully, I would suggest that it be very limited in terms of what it addresses. There is possibly a violation of 67.16, and I think it goes to what at least one of the speakers has said. There's a difference between a general description of a topic and an actual summary of what someone says. And what could be construed here is that the violation of 67.16 occurred in that there was not a satisfactorily clear, precise summary of each person's statement during the public comment period. If Mr. Highland doesn't want to make that motion, I will.
Member Popa had one last comment first, and then...
I didn't say this earlier because I didn't feel compelled to, but I do now. I would note that the requirements of the ordinance as to content of the minutes has this provision about public comment and what needs to be in and the summary and all the things that we've been talking about. There's nothing in the ordinance, and frankly, there's nothing in the charter about the record that's made of meetings and actions taken that requires any summary of comments of members. And I would note that greater than 90%, 95, 98% of the discussion at Board of Supervisors meetings is from members of the board and members of the staff relative to legislation. And I would further note that the primary purpose, in my opinion, of the Board of Supervisors is to act on legislation. And what members of the board say goes to the question of legislative intent, sometimes legislative findings and legislative construction, and is actually bears on the legality of legislation if it's in contest later. And so if and when that comes up, people, again, can refer to the actual tape. We've got audio, we've got video, we've got lots of real live recordings. And so this focus, if you will, on how public comment is summarized in the minutes, I think is
part of a bigger picture.
It reflects a concern, certainly, but I think the language of the ordinance struck a balance between having armies of people just sit there and transcribe and try to summarize, and is this a summary or is this a topic list or is this enough of a summary, versus just having a record that says this person showed up and talked about taxi issues. There you go. If you have, essentially if you have more concerns, you can go to other media to find out that there is a record made of the actions taken and of the fact that someone made public comment. I'm done.
Member Nee, if you'd like to repeat that motion, I'll be happy to make it.
The motion would be to find violation of Section 67.16 for failure of the minutes to summarize, where are we?
Each person's statement.
Summarize each person's statement with sufficient clarity or precision during the public comment period.
Are you making it and you're seconding it?
I can do it that way too. I'll second that motion.
All right. Put me down as the maker.
Okay, great. It's been moved in second. Yeah.
Precision.
You guys all understand the motion? Okay. Then I'd like to know if there's any public comment on this motion that has been put forth.
Thank you very much, Peter Warfield. I think the motion is appropriate. I'm only a little concerned if other members think that precision and clarity is perhaps too high a standard. I would say adequately summarize, but that's up to you. The idea that other mechanisms are available for people to, this is a shell game. Oh, if we didn't meet our obligations under the law here, why, you could always go to the tape and listen to a 6-hour meeting. I made public comment yesterday after 8 p.m. That's when they called public comment. Nobody is going to look to see whether their interests are concerned or what whether that's something they might want to do to track down the actual comments, when every single description is the same and it's just a topic listing. You well know that Mr. Chafee has certain issues that he very particularly mentions, and particularly he talks about the Friends. That's not mentioned here. He's very keen on the Friends. He starts every single comment out, don't give money to the Friends, don't take money from the Friends, so much so that in a prior hearing, you heard a library commissioner repeat his phrase. Is there anything about the Friends here? These are completely inadequate as summaries. And with respect to one of your members who just said that the members of the body are not summarized, that's their choice. The reason the ordinance provided that the public has to have its comments summarized is because the public has no power as you have amongst yourselves to decide what level of minutes you'll accept, what level of minutes you want. The public has no power to tell Mr. Caldera or Angela Calvillo, oh, I wish you would say this and such about what I said, or that and such about what I said, unless I put the 150-word summary, which I don't want to do. It's a lot of work. It's a lot of extra work. Then you can get into fights over where in the minutes do they put those 150-word summaries. The law requires a summary. Read the law. And it doesn't say where or if or when. It says unconditionally requires a brief summary of each person's statement during the public comment period for each agenda item. So I urge you to vote in favor of this, because otherwise that portion of the law has become meaningless. Thank you.
Is there any more public comment on this motion?
From time to time, I'll go to a hearing and I'll speak about certain issues. So I won't really be speaking for or against anything. And then I might, like if we're talking about homelessness, I might talk about homelessness, and then I might go off into the quality of the SROs regarding why people would choose to be homeless rather than living in an SRO, which has bed bugs, rice, rodents, roaches, etc. So to kind of like make what I would have to say a very myopic thing, where I've actually spoke about two important issues, it just feels like it doesn't seem appropriate. And then two, if one time one of the members asked me, well, what are your ideas towards a solution? I started listing out solutions. Do this, do this, do this, do this, do this. And it's not like I spoke, to me it's not like I spoke about something. It was just like I gave you a very clear, defined list as to what you should do to make these situations better. And then to just blow it off like, oh, I spoke about homelessness in a meeting, to me it's not appropriate, because I spoke about homelessness, then I spoke about the quality of SROs that would actually make people make those other decisions. So I think we need more clarity. And the other thing too is these records are supposed to be preserved against earthquake, fire, national disasters, nuclear warhead landing on somewhere. So, there'll probably be a time coming when we won't have electricity for maybe a couple days, a couple weeks. So it goes back to the minutes. Craziness if we're trying to put out fires in the city again, and you want to look at minutes from a meeting like 10 years ago, craziness. But if it happens, then that should be there, and that's the reasons for the minutes, so that we have something more clear.
Thank you. Is there any more public comment on this issue? If not, I'd like to take a roll call vote. Madam Clerk?
On the statement, 6716 summary of each statement was clarity and precision. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Pass.
Pass. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
No.
Vice Chair Fisher, no. Chair Grant, let me go back to, Member Sims?
No.
Sims, no. And Chair Grant?
No.
No. You have 5 noes and 4 ayes.
Great, thank you. Thank you. Have a good night. The matter is concluded. Did not pass. The motion did not pass. Madam Clerk, can we go to the next item on the agenda?
Item number 9, file number 13027, complaint filed by Ray Hartz Jr. against Paula Jessen, District Attorney, for allegedly violating 67.21I.
I'm sorry, on the item itself, it says District City Attorney. Should that read Deputy City Attorney? Ms. Clerk?
Yeah.
Yes. On the caption of the item. Sorry.
She's busy, leave her alone.
Yeah. Deputy, so, it just,
On
yeah,
that
it's a
line,
should.
it should
So
say
she'll make no correction. So before we begin, Mr. Song was here earlier. He is no longer here, just so everyone knows that. So just to put that out there, first of all. So I'm sure Mr. Hartz would still like to, please come to the podium if you'd like to proceed with this, I'm sure.
Point of order, jurisdiction.
Oh, sorry, yeah, that's right. So, well, since the other party's not here, Mr. Hartz accepts jurisdiction. Ms. Lee, I mean, that is a jurisdiction for the city attorney.
I don't see any issue. I mean, they responded. They never brought up the issue of jurisdiction.
He
So.
showed up, yeah. Okay.
The memo, on the memo.
Yeah, the memo that
Yep.
he accepted, they accepted. Here.
There's a line in here, page 203 of our packet, two sentences actually under jurisdiction, second paragraph. The documentation in this matter reveals that complainant complains of the denials of petitions to the supervisor of records. The city attorney is the supervisor of records. City attorney contends that the task force lacks jurisdiction to overrule or modify a determination by the supervisor of records, even if the task force were to disagree with it.
Correct, that's true.
How does that work into the question of jurisdiction to hear the complaint which you addressed in the previous graph? You're suggesting that we have jurisdiction to hear the complaint, but we don't have jurisdiction to overrule the determination of the supervisor of records. Is that what I'm reading?
I think that really hinges on what the complaint is about.
Okay, so I guess my take is that to the extent that the complaint relates to the determinations of the supervisor of records, since we have not jurisdiction to review those, that I don't think we have jurisdiction to hear the instant complaint, and I'm inclined to vote against jurisdiction if there's a motion.
Madam Chair, I move to find jurisdiction.
Do I have a second?
Second.
It's been moved and seconded. Second. Sorry, it's tired.
Let's take a public comment and a roll call vote.
I wanted to ask if there's any public comment about this issue's jurisdiction for anybody.
Peter Warfield, Library Users Association. We certainly think you have jurisdiction. And I'd like to remind the task force of how often this task force has ignored or overridden city attorney opinions. You just heard how an outside authority, a judge in Superior Court, ruled that Alan Grossman was correct in a case where the city attorney advised the department that they could do one thing, and Mr. Grossman said no, they have to do another. The city attorney was overruled by a Superior Court judge. I don't know how often in your tenure you have observed advice from the city attorney being ignored, but I can certainly tell you that there have been numerous cases that I have personally brought where the city attorney, in one case, as an example, to me one of the most outrageous ones, and this happened some time ago, city attorney said in a lengthy decision...
Point of order, Madam Chair. With respect to the speaker is not addressing the motion that's before us.
Jurisdiction.
The issue raised was the city attorney has perhaps implied or does imply that you don't have jurisdiction. And what I'm saying is very relevant, and that is it doesn't matter what the city attorney says. You get to decide. And as I was about to say, one of the cases that I brought, your city attorney sitting here wrote in an opinion that was put into the agenda that the task force did not have jurisdiction because my case was wrong. The task force overruled it, took the case, and I won. So there's nothing holy about whatever the city attorney might state. You determine whether you have jurisdiction. I believe you do. I agree with the maker of the motion to find jurisdiction. Thank you.
May I make public comment on this?
Great, thank you. No, because you're a party into the action, so you can't.
This is jurisdiction.
Actually, I think you can.
Yeah. Ms. Lee? Let me just double check, want to make sure I'm doing it. I think as a party to the...
We've heard from parties before in jurisdiction.
I think you can.
Yeah.
Okay. Thank you.
I'd like to very briefly say that I really question this whole discussion because of the fact that there was a representative of the city here. He chose to leave. If he chose to, he lost his rights to deny jurisdiction. If he thought there was a jurisdictional issue, that's one of the items on the agenda. He could have been here to discuss it. I don't know whether he's still in the building and he could be called, but the bottom line is he chose to leave. And as a result, I don't see how other people can put forward the jurisdictional issue because they don't have standing to do so. Only the respondent or their representative, I believe, has the right to say you don't have jurisdiction and give their reasoning as to why.
Great, thank you. Is there any more public comment on the issue of jurisdiction? If not, then... Did he speak?
I guess my problem with it is we have to, I just feel like you're talking about city and county of San Francisco's resources.
We're talking about, just to be clear, we're talking about jurisdiction.
You're definitely correct.
So we want to keep
and that's why I'm bringing the thing is you're talking about jurisdiction, but it's the resources of the city and county of San Francisco. So I think that for me it's jurisdiction because it's the resources of the city and county of San Francisco. So that's why I think we should have jurisdiction.
Okay, thank you. Is there any more public comment on this issue of jurisdiction? If not, it's been moved and seconded. Can I get a roll call vote on this issue of jurisdiction?
On jurisdiction, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Vice Chair Fisher, aye. And Chair Grant?
Aye.
You have 8 ayes and 1 no.
Great, thank you. So now, let's listen to the substance. Mr. Hartz, you have 5 minutes.
As this task force is well aware, there is an outstanding recommendation to the Board of Supervisors to find Luis Herrera, the city librarian, in violation for withholding public records. The board refuses to take that up at all. Included in that recommendation was that they instigate some sort of an investigation into the funding of the Friends of the San Francisco Public Library. In the process of doing this all, I made public records request. Mr. Herrera dragged that out for a year. I finally did a petition to the supervisor of records saying, this guy's got records. I identified specifically several records which he did not produce. She got him to give me some of the records, but he just failed to respond to some of the others. But then basically, and this is in the report that they did to you, the 13th annual report of the supervisor of records to this body, it says Petitioner Ray Hart's Department Public Library, records relating to the Friends of the Public Library, determination denied. The library has provided and was continuing to provide responsive records. As a request for assistance, the supervisor of records does not generally determine a department's compliance with the requirement, but in any event, the library has demonstrated its willingness to assist. Okay? So, we go another 6 months. I'm still being denied documents. He's giving them a few at a time, a few here and a few there. I put in another petition to the supervisor of records. Now, at what point can I say to the supervisor of records, look, the first time I gave you the petition, you gave them the benefit of the doubt and said my petition was denied because they're making an effort. Now we're here a year and a half after the original request for the records, and they're still fighting them. And she got him to actually produce more of the records. So it wasn't just me saying there were records and nothing to show for it. The second request from the supervisor of records produced more records. Now, you heard earlier this evening from a couple of members of the public about the Fair Political Practices Commission in Sacramento finding Luis Herrera in violation of the Fair Political Act. The bottom line was Mr. Herrera perjured himself 3 years. He signed a declaration under penalty of perjury that he had received nothing of value from the Friends. He has been subsequently forced to file new filings, which all indicated in each year he received thousands of dollars of gifts of travel, hotel accommodations, and so forth from the Friends. Now, the documents, at least some of them that were significant in getting the FPPC to come to this conclusion, were part and parcel of these requests. Now, it says that the supervisor of records will not, or the city attorney will not act as a counsel for a body attempting to withhold public records. But you can act as a counsel for somebody in that manner either by acts of commission or acts of omission. In other words, I'd simply just say, oh, I'm going to deny the petition based on the fact that, well, they're giving you records, and they're still giving you records, and they're going to give you records. Or I can say, just give Mr. Hartz the records. You know you're required to do it. And my job as a supervisor of records is to deal with the issue of you deny records, he's saying you did, and I've got a long established history right now of showing that you have. This is not a case where I say he withheld records and there's some question about whether he did or didn't. This is a fact that for 2 years he has withheld these records, and you can understand completely why. I'm a member of a city body. I'm a department head. I've been receiving thousands of dollars of gifts from a group over which I'm supposed to have oversight and over the interests of the public library, which I am supposed to protect. And Mr. Hartz has fought me and finally gotten all these documents to show that while I was accepting these gifts, I did absolutely nothing to determine where the $53 million between 2001 and 2012 went. And yet I've gone before the public at the same time and made open statements saying that this whole relationship is great for the library when I have absolutely nothing to support that. And in this particular case, if she wasn't the counsel, she sure in heck might as well have been.
Thank you very much. Is there anyone in the public that wants to introduce any facts or evidence in support of Mr. Hartz? If not, this is the opportunity that we normally have the respondent to make his case, but he is no longer here. So I would like to open it up to...
Ma'am,
are there any...
facts and evidence in support of the respondent?
Is there anyone in here that has facts and evidence in support of Mr. Song as a representative? No? Okay. In that case, I'd like to open up to the task force members to ask any questions of Mr. Hartz. Does anyone have any questions? Okay. In that case, Mr. Hartz, I'd like to offer you the opportunity to offer your concluding facts. 3 minutes.
One of the things that Mr. Grossman asked me to consider mentioning, and I think he has a very valid point, was the fact that why Mr. Song was here representing the city attorney's office when the supervisor of records is supposed to be an independent, functioning individual. In other words, they are not supposed to say, I'm in the city attorney's office and therefore I will make decisions in light of the city attorney's opinion one way or the other or anything else. They're supposed to be an impartial person who listens to the petition, asks the group whether or not you've given the records that were requested, and if not, why not? And if they have failed to do so, order them to do so. Okay. In this particular case, the first time she failed to do that, I had to go back a second time. And again, we're not talking about going back a second time and getting nothing but, nothing. We're talking about going back and getting substantive records, which went to show a violation of state law. And that has been adjudicated by a state commission, the FPPC. And the Library Commission continues to want to make light of this and say, oh, these were just bookkeeping errors and Mr. Herrera didn't understand. They're just covering their own ass. Because basically, they're responsible for the city librarian. If the city librarian, year after year after year, filed under penalty of perjury false statements, had to then go back and refile giving the correct information, they are, to a degree, responsible for his behavior. But in this particular case, what I'm focusing on is Ms. Jessen. Ms. Jessen will send you page after page after page after page after page after page of what the supervisor of records doesn't do. I have yet to see her say what they do. And yet she will come before you each year and say, petition denied, petition denied, petition denied, petition denied. And in this particular case, the petition denied just allowed the city librarian and the library commission to continue withholding the records for a longer and longer time. It perverted the course of justice because the subsequent complaint had to be held until earlier this year. And if they had given the documents at the time we asked for, this all would have been done a year and a half ago. And bottom line is what the city attorney, Paula Jessen, did, deputy city attorney did, was permit Mr. Herrera to continue in his efforts to withhold the public records. And I would say she did that by an act of omission, by simply denying her responsibility to do anything at all.
Thank you. At this time, I'm wondering if there is a motion to find a violation of the Sunshine Ordinance based on the information we have. Member Nee?
Madam Chair, I move to find Paula Jessen, the supervisor of records, in violation of Section 67.21D, D as in David, for failure to, failure to immediately order custodian of public record, of a public record, in this case, Mr. Luis Herrera, to comply with the complainant's request for records. I also move to find violation of find Ms. Jessen in violation of Section 67.21E for failure to appear before this task force to answer questions.
What is
67.21E.
21E, it refuses to. That's the one for not showing up.
He just didn't show up.
Failure to appear, failure to send an eligible representative.
Yeah. I'll second.
Thank you. I'd like to open it up to any members of the task force. Public comment about this motion?
That's the first one, public comment.
Oh, I was asking if anyone had any comments. Did someone have any comment from the task force? I didn't see anyone. Oh, I'm sorry. One moment. Member Pell and Member Washburn?
So based on the information before us and the testimony of Mr. Hartz, I guess I am not persuaded that there's a violation. In particular, I mean, clearly there's no one knowledgeable, there's no one here for the other side, so, there's a potential 21E issue. But with regard to 21D, where the supervisor of records made a determination that a record was public, I believe they did inform the petitioner as such, and required that that record be disclosed within 10 days, or, within the applicable period. Just because a petition was denied or there were several petitions necessary to obtain a certain result, I don't think makes for a 21D violation nor any other. And the underlying complaint here that the particular individual, Ms. Jessen, was somehow providing legal counsel for city employees for purpose of denying access to the public, I think is fundamentally not the case. In the role of supervisor of records, Ms. Jessen does not provide legal counsel for city employees, but merely provides a third-party review of records that were not provided and determines whether or not they should have been provided under the ordinance in a parallel process to a complaint hearing before us. So I would vote against the motion. Thank you.
Member David?
I just want to say that I respectfully disagree with Member Pilpel, and I think that it is, I think it's pretty hard to make assumptions as to what Ms. Jessen does or does not do without someone from her office here speaking on her behalf. And that's, I think, at the end of the day, it's really, really difficult to represent. I don't think it's our job back here to be representing somebody else's thoughts or ideas. And if they're not going to take the time to come here, I think Mr. Hartz has made a pretty thorough argument, and I haven't heard anyone counter that argument. And until someone stands up there and counters it, I'm going to have to support this motion.
Great.
Did we add failure to send someone?
Yeah.
Okay.
So that's E. At this time, can I open up to public comment on this issue? Is he?
Peter Warfield, Executive Director of Library Users Association. I'm not intimately familiar with the case, but number one, I support the motion. Number two, I would suggest that you take a look at another violation which you have omitted to mention. And I have brought this up repeatedly when the supervisor of records has brought an annual report. And I've said that they've hidden their failure to heed the law in a particular case, in this instance, timeliness. Section 67.21D says the following: if the custodian refuses, fails to comply, or incompletely complies with a request described in B, the person making the request may petition the supervisor of records for a determination whether the record requested is public. And that's what Mr. Hartz did when he applied to the city supervisor of records. Here's a key sentence. The supervisor of records shall inform the petitioner as soon as possible and within 10 days. Let me repeat. The supervisor of records shall inform the petitioner as soon as possible and within 10 days. What do we find from the Office of the City Attorney on your page 212? Dear Mr. Hartz, you filed a petition with the supervisor of records on June 8, 2013. What is the date at the top of the letter? July 8th. Exactly 1 month. So the 10 days that the supervisor of records is required to give a response, the maximum, as soon as possible and within 10 days. 10 days is a maximum. We have at least 30 days. That's more than 4 weeks, not 10 days. So I certainly ask you to find a violation. Additionally, on that basis, the supervisor of records, I can tell you and have told you repeatedly at the time that they've come with their annual report that they typically don't put the date of the request. They don't do it because if they did, it would show what we see here, a gross violation of the speed requirement, and that's one of the reasons D is in there, so that people can get a quick response and a quick determination. Thank you.
Thank you. Is there any more public comment? If not, is the maker of the motion want to amend anything, or you want to keep it as is?
Well, with respect to what Member Pilpel has said, perhaps a separation would be in order. Separate, to make it two motions, one to find violation of 6721D as in David, the other to find violation of 6721E.
I think.
Okay, Member Pilpel has indicated he does not want a separation. I would add that Mr. Pilpel has said that the city attorney has not defended the city or a city employee. The city attorney has not acted as legal counsel for the purpose of denying access to of a record to the public, but that's not in Section D. That's
Section I.
That's 6721I, and that is not part of the motion.
That was the complaint.
We need to put that in the motion.
It doesn't need to be. Can I just
Yes, Member
point
Pilpel.
out, in response to the public comment, one can also read the sentence to mean...
Well, let him finish his thought, please.
Okay, I'm sorry. One can also read the sentence in question to mean that the supervisor of records shall inform the petitioner of its determination as soon as possible and within 10 days, again, of its determination without a deadline as to when that determination is made, and furthermore, that the deadline, if there is a deadline in 67.21D, can also be read similar to the 45-day deadline in 67.21E, which we were previously advised has no particular consequences for failure to abide and therefore is directory only. Thank you.
Okay. So, Member Nee, do you want to keep your motion as is?
Yes.
Okay. Can you read that to all of us one more time, just so we know exactly what?
Motion made by Member Nee, seconded by Member David. Violation of 6721D and 6721E for failure to immediately order a release of records and for failure for a respondent to appear.
Oh, wait, no. Yeah, that's about right.
Okay. Can we take a roll call vote? I'm sorry, I wanted to clarify.
No, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
Aye. 8 ayes, 1 no.
Jeez.
Great. So the matter is concluded and the motion passes. Thank you for coming tonight. Madam Clerk?
Number 10, file number 13028, complaint filed by Charles Pitts against the Community Housing Partnership for allegedly enforcing illegal group guidelines.
I'm sorry.
Wait, let me just...
Just a quick question for Deputy City Attorney, excuse me. Do we need to refer the last case?
Oh, yeah.
Like, that would be helpful.
That would be, I believe that would be to the call of the chair.
To refer,
Committee referrals, well, it can be either way. It can be part of the motion, or it can be to the call of the chair.
You know what? Yeah, I'm going to refer this to compliance and amendments. Thank you. Makes sense.
Written down right there.
Just good catch.
Yeah,
Thank
thank
you.
you. Thanks.
No, I was like, no.
We got our goalie on the end of
Okay.
there.
Did you, I'm sorry, did you read the next item? Okay.
Thank you.
Actually, before we start that item, I had a quick disclosure. I see that there's a representative of the respondent Community Housing Partnership here.
Yes.
Okay. I know two individuals, and I'm friends and associated with two individuals who work for CHP, but they're not significant management employees, and I don't think that'll bear on my decision-making here. I think that needed to be disclosed. Thanks.
Okay. Do you guys have a problem with that? Okay, great.
And I don't think we've met. I don't even know who the individuals are.
Do you, Mr. Pitts? Member Pil-Pal?
That's good.
Okay, cool. Okay. Well, hold on a sec. Let's get this straight about jurisdiction, because there is an issue with the jurisdiction. So,
see how this is, our jurisdiction, this one.
Celia, if you could explain the issue at hand before we get into making a vote on this.
Sure. It's, you know what, I don't think this is a memo that made it into the packet, but hopefully you guys all received it.
Yeah.
Charles, did you get these two memos that were out there tonight?
I believe I received them when I got to the table and picked them up.
Okay, so you looked at, okay.
I have a brief glance at them, but that's about it.
Okay. So if you could explain to the members, maybe to everyone, so they can hear.
Okay. There's the issue of whether the Sunshine Ordinance applies, and then there's a separate issue of whether the Nonprofit Organization Access Ordinance applies. The members of the task force have the ability to hear matters regarding both violations of either ordinance, and I'll start there. Do you have specific questions? Well, let me say this. It's a private, it's a Community Housing Partnership is a private nonprofit organization. I've determined that it contracts with the city, and it receives funding of over $250,000, in which case the Nonprofit Access Ordinance would apply. It is not a policy body and does not qualify as anything otherwise subjecting it to the Sunshine Ordinance or the other public records laws.
Got it. Okay.
So,
thank you.
Can I ask a question?
Yeah.
So I'm really curious about this. So if a random nonprofit in the city that, say, gets a grant from the arts for $50,000, I mean, are they considered what you just said?
Are they subject to the nonprofit
Yeah, I mean, can somebody
organization?
file a complaint against a 501c3 that happens to get a grant for the arts, but is an independent 501c3?
Anybody can file a complaint anytime, but whether they're actually subject to the jurisdiction is a different matter. The threshold for being subjected to the nonprofit organization access ordinance, which is Admin Code 12L, is contract with the city and receive funding of at least $250,000. So in the situation that you mentioned, no.
I thought there was some, so that's the ceiling, or the...
That's the threshold.
Floor. Yeah.
Right.
Thank you.
And
Member Pil-Pal?
two
Admin
things.
code, wait a minute, admin code, what was that?
12L, Chapter 12L.
Thank you.
And to be clear, there was a lot of discussion in 1998 when that ordinance was enacted about what the threshold should be, how how many organizations would be captured, and there are certain exclusions. One should read carefully 12L as to what the requirements are on those nonprofits that are subject to it. So to the item before us, and actually it relates to both, what is the, and I don't know if Ms. Lee knows, perhaps the representative from CHP does, what is the city agency that has the largest funding agreement with CHP? What is the city agency that would potentially be at issue here? Is it HSA? Is it DPH?
It's Human Service Agency.
HSA, okay.
But it's not, but, okay.
It's through some part of HSA.
That's the answer to that question, yes.
Yeah, okay, cool, thanks. So as part of 12L, there are certain steps that an individual has to take in order to get before the task force to issue an advisory opinion.
Yes.
And the question in my mind that is central to jurisdiction is whether or not those steps have been complied with. Specifically, did Mr. Pitts seek mediation through HSA with respect to CHP over his concerns with compliance with 12L? If so, and we need to understand how that happened, then I think jurisdiction is proper and before us. If not, then I think jurisdiction is not proper and both matters are probably not before us. So I think we need to hear about that at some length before we get into the merits, if we do.
Exactly. Mr. Pitts?
Thank you.
Thank you. Can you answer that question for Mr. Popo?
Well, I think the legislation says may, not shall. So I believe that it's not a contingent that I make go to the Department of Human Services, but I think that okay. And the other thing too is about it is I did speak with the Director of Contracts and Management, and I really didn't get anything like substantial. He was sort of in my favor, but he never really gave me anything like substantial. And then the other thing about it too is there have been letters and documents and things, not regarding this issue, but that I haven't gotten responses to. So I think right now I just feel that I need, trying to mitigate it through the Department of Human Services. They probably wouldn't even give me any type of response. I mean, I called him and I was lucky to reach him, but chances are they are not going to try to mediate any of this.
So you did reach out to HSA?
Yes, I did.
And the response was, you got a written response? What did you get? Because that's the steps that have to be
It was a phone call. I talked to him. It seemed as he was sort of in favor of some of the stuff that I was talking about, but it really wasn't clear.
Member Nee?
My question is for Ms. Lee.
Okay.
Question for Mr. Pitts. The meetings in question, these were tenant meetings or board meetings?
They're tenant meetings, but there's several.
Thank you. Ms. Lee, do tenant meetings fall under 12L or the Sunshine Ordinance? And that goes to the jurisdiction question. If these are tenant meetings, jurisdiction may not be there.
No, they do not.
Board of Directors meetings.
Member Popo?
Lee, I finally found
Speak into your microphone.
Yeah.
Right. I finally found the binder out there. You've got 12L there.
I have 12L, yes.
Can you walk us through 12L.5B, dispute resolution, and whether or not mediation with the department is required? You may not have to read the entire paragraph because it's lengthy, but at least that portion that's germane, unless you had it in your memo and I missed that.
Because some members of the task force, I don't know how often in your history this has come up, but I'll certainly walk you through it.
Oh, I'm sorry. It is in the memo, but yeah, you may want to.
It is.
Yeah,
Sure. So Section 12L.5 governs public access to records, and it subsection B is entitled Dispute Resolution, and I'll read that. A member of the public who requests additional financial information other than that described in Section 12L.5A above, or who has a complaint concerning a nonprofit organization's compliance or noncompliance with this chapter, may submit that request or complaint to the city agency or department which is a party to and or which administers the nonprofit organization's contract. That city agency or department shall consider the request or complaint and shall recommend a resolution thereof in accordance with procedures established by that city agency or department. Following such consideration and recommendation, the member of the public or the nonprofit organization may seek an advisory opinion concerning the request or complaint from the Sunshine Ordinance Task Force, which that task force shall be authorized to provide. So, thank you.
Et cetera, yeah.
Yeah.
So hearing that, it seems that one, we have to be in an advisory role, and two, you had to have gone through the process with HSA to seek mediation before we could even hear this case. Correct me if I'm wrong, but that there is a step that hasn't been taken yet, that we don't know what, there has to be some sort of mediation before it comes into our jurisdiction, and we're just really providing you advisory thing. There's nothing that we would be able to really refer this to, it's none of that. It's really just more of an advisory role. Please, I'd like to open it up.
Madam Chair, also, the complaints here deal with meetings access, not records access.
Yeah.
So, and again, we're advised by Ms. Lee that tenant meetings and board meetings are not the same creature.
Yeah.
With respect to applicability of the various statutes.
I agree. Member Pilpel?
So, Charles, before I get to you, I'm sorry, we haven't even been introduced to the HSA representative, or I'm sorry, the CHP.
CHP.
It's late. Yeah.
Community. Hello, I'm Lisa Blakely. I'm Director of Support Services, and I'm representing Community Housing Partnership. So I did actually also have a question about jurisdiction. But I'd like that concluded.
Director of Support Services for
Director
CHP?
of Support Services, yes.
Okay. In your role or someone within the CHP orbit, do you have a point person with HSA on contract issues, whether it's Dave Curdo or somebody else?
We have a number of point people depending on, we have contracts and we have point people for
services.
So there are a number of people, but Joyce Crum is the main point of contact, I would say. Yeah.
So has Mr. Pitts, obviously you got this through our office, has Mr. Pitts come to you or to someone within your organization with these concerns about the tenant meeting or procedures, and have you or has somebody attempted to address the concerns directly or using HSA or somebody to attempt to mediate? Has any of that happened to your knowledge?
So for the first question, actually, we have definitely received the concerns from Mr. Pitts directly, not from the Human Service. Well, actually, let me back up. Both.
Okay.
Actually, yes. Both.
And is someone attempting to address them, whether valid or not valid?
Yes.
Okay. And that's ongoing? There's been no...
It's at least, again, for our perspective, yes, absolutely.
Okay.
We responded directly to HSA. The person, Ilanda Callaway, has sent an email directly to me. I responded to her. There's documentation of the response and what our actions were. Whether or not they've satisfied Mr. Pitts is a different matter.
Okay. And that person is a Joyce Crum person?
She works for Scott Walton, and Scott Walton works for Joyce Crum.
Okay.
So she's
These are
a couple
folks
levels
within
below.
homeless services within HSA.
Okay.
Dave Curdo is the contracts guy for HSA.
Correct.
Okay, so if and when that process results in something that can be brought back here, you're happy to be back, but it may be that we're premature at this time.
Well, that's my question, because even if it did come back, my question is about jurisdiction, because the matter is not about a board meeting, it's a tenant meeting. So I would like clarification about how that matter would come back, given that it isn't within jurisdiction.
Or it may not be within the jurisdiction of the task force, but the city may have other procedures within HSA about whether the services are being provided in dispute resolution about contracted nonprofit services that are unrelated to Sunshine.
That's absolutely true. It's in our contract. We have a grievance procedure, and they have their home process of following up with us to resolve those kinds of disputes.
Perfect.
So-
Lee, I'm sorry, she wanted to interrupt and say
Sure,
one thing.
and then I had a question for Mr. Pitts.
I just wanted to point out the difference between jurisdiction and actually hearing the merits of a complaint.
Okay.
So the Sunshine Task Force has jurisdiction to hear complaints regarding the nonprofit organization access ordinance. So I just wanted to leave it at that.
Generally.
Generally.
Generally, yes.
Right. So if I could then to Mr. Pitts, I think what I'm saying, and I don't know if we have concurrence on the task force, is that this is not ripe for us to hear at this point, and it might not be ultimately that it sounds like you're engaged in a process with CHP and with HSA to address the concerns, and that may be the appropriate route, and until that's completed, we're not here on this, and we might not be the folks if it's just about the tenant meeting and not related to financial information or the board of directors of CHP. Does that make sense?
Well, see, what the problem is with the laws is like there's emails going back and forth between the Department of Human Services and this organization, and I don't even have the right to get those under your 12L laws. So they're talking all about this case back and forth, and I get nothing. Even if they are trying to mediate this problem, I'm not entitled to have that document according to your laws.
I don't think that's true, actually. If you go to HSA and say, I'd like a copy of all the email between HSA and CHP related to your concern about tenant meetings at the, what was it, Arnett Walton House? Yeah. They should provide those. And, I mean, subject to whatever redaction, if there is any, but it doesn't sound to me like...
So if I ask and I bring it back to this body and they refuse to give me information, then
we deal with that in the way that we...
Okay, so is that a violation?
We're not there yet. Let's one thing at a time. If that's the information that you're interested in, I would assume that someone at HSA would respond to that request.
I mean, see, to me, it would have been a whole lot better if they would have spoken to me. I mean, my history with CHP, they got these waivers from the city of county in San Francisco, and they violate court orders. They violate court orders. It's really like they're in the pocket of the city and county of San Francisco, and on many levels, it just really seems like they do what they want. Well, and then they got this. Then they got this here. This, So it's like what rights do the poor and impoverished have?
I'm not arguing or debating the merits of CHP. I just think that I think they have your attention now, whether they did or didn't before.
I think they don't care. I think they just
I don't know if they do or not.
I mean, I can show you my court records, and chances are they don't.
Okay. All I'm suggesting is that if you pursue HSA, which is supposed to have a process...
I did talk to David Colonel. I did talk to him.
Okay. Well, it may...
But have you asked for the documentation that you're saying that they're having all these conversations?
This is the first time I've ever heard of it.
Okay, so...
So that's a follow-up,
yeah.
And it may be that Dave Curto has some information on the contract side, but that Joyce Crum and her people have things on the services side.
I mean, you're saying all of this, and my experience is they molest us and just extract money from us.
Okay, I can't respond to that. I'm just trying to help get you to a place where your concerns can be heard.
So let's wrap up because our jurisdiction is...
I think the way it reads is that I do have jurisdiction but we're going from jurisdiction to the merits of the case. So, I mean, I just see it like, I mean, I just feel like if we go to a meeting, then we should have some type of record of what happened. We should be able to, like, record this meeting. We should have some minutes. I'm looking for basically just the basics so that
We have to back up, sir, though, because we're coming back to stick to the jurisdiction issue right now, because the merits of the case is two separate things. We do not have jurisdiction. We will take a vote, but listening to it and listening to the advice of the city attorney and listening to the nonprofit and listening to the idea that you want about the meeting, it's not a board meeting, it brings to light a whole bunch of problems, and the fact that you have not had an official mediation with HSA, it steps to the process.
And then,
so
okay, but see, then with that scenario, what happens when HSA doesn't respond? I mean, there's no time limit on any of this, so I could send them documentations, and chances are they're not. I mean, what if they don't even respond?
I see. Yeah, Member Oka.
Madam Chair, I'm still not clear whether Mr. Pitts has contacted HSA or even has attempted to contact.
He said he called them, but I don't think there's any record or anything of that sort. Have you heard, I'm sorry.
I mean, I can show you my phone. I can show you that I did call him. I mean,
did you speak to him?
You called HSA?
No. I called David Curto, and David Curto, he's the manager.
Contracts guy at HSA.
Yep.
Contracts manager.
Okay.
Because if you look at my phone here.
You can call HSA directly yourself?
I mean.
You can call HSA yourself.
I mean.
To get this information on your complaint if you wish to. You don't have to wait for somebody else. You can contact them yourself.
But you're bringing up. See, part of it is like I didn't even know that this information was there. I mean, if you look at the phone log, you can see David Curto. You can see 2:22 p.m. right there on the phone. So that's. Let me see if I can. I'll pull up another. Let me.
Okay. You don't have to pull it up. That's fine.
I mean, I got 2 minutes here. I mean, I've
But that's not the issue, sir. I understand what you're saying. Okay.
I mean,
it's a difference between mediation and what has come of that conversation. Or are you saying you just called him and left him a message and nothing?
No, I talked to him.
And what do you have something that you know furthermore about this?
What I do know is that I received an email from Yolanda Calloway in reference to some concerns that Mr. Pitts expressed, and I responded. So there is documentation that HSA reached out to Community Housing Partnership in reference to the concerns that Mr. Pitts expressed. So there is documentation. Whether or not Dave passed that information over to Yolanda, that did happen. Then secondly, I just want to note, even if this comes back and we're talking about tenant meetings, it's not a public meeting, and some of the concerns expressed are about whether or not there's the ability to tape record, or in those matters, people who are tenants and residents have rights that don't fall under those. So there's a lot of complexity, and if it does come back, we want to at least have some understanding about what the particular matter is. Because also there's been a discussion about budgets, and we're not talking about agency budgets, we're talking about tenant council budgets, which aren't even our budgets. It's a separate body. So I hope that before we come back, all of that there gets to be some clarity about that.
Okay.
About what we're here for.
Yeah.
I mean, but she's bringing up this, but a tenant council budget, that is a subsection of their total budget. I mean, prove it. Just prove it. Prove it.
Yes, heard enough. Member Nee?
I mean, the community housing partnership gives them
We've heard
money.
enough now. Okay, we've got it. Member Nee?
Madam Chair, I move to find no jurisdiction.
Do I have a second?
Second.
Great.
I'm sorry, to Ms. Lee, do we need to take action to find no jurisdiction, or is that the result of not finding jurisdiction?
No, because it's a waste of time to do anything.
I think simply for clarity's sake, you may want to.
Take an action to not
Yes.
find. All right, fine. So who moved and seconded? I'm sorry.
Member Nee, and who seconded? I'm sorry. Oh, Member Highland seconded.
Thank you. And are we sort of applying this to both items 10 and 11?
Or do we need to do
No,
them
let's take them
separately?
separately.
Take them separately.
Separately? Okay.
Okay, great. I'd like to ask if there's any public comment. Great, then can I take a roll call vote, Madam Clerk?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Fisher?
Aye.
Fisher, aye. And Chair Grant?
Aye.
You have 9 ayes.
Great. Thank you. This has passed. Matter is concluded. There has been found no jurisdiction. We do have the other case. Madam Clerk, can you read that for me?
File number 11, file number 13029, complaint filed by Charles Pitts against Community Housing Partnership for allegedly denying the public to record the May 21st, 2013 meeting.
Jurisdiction has been contested by the respondent. Do you want to say anything in regards to jurisdiction regarding this case in particular?
Anything different?
Again, I guess I'm not exactly clear which tenant meeting, or if it's a tenant council meeting. If it is anything other than a community meeting, the tenant council meeting is a separate entity. It's not a community housing partnership entity, and so it's not something that we are required to provide minutes for or anything of that nature. So that's, I guess, what I want to say about that. So I would need clarity about that.
It's still the issue of jurisdiction of if we can hear a case from community housing.
Right. But these are all tenant meetings, non-board meetings.
Yeah.
For clarity.
Exactly. Okay. Thank you. Mr. Pitts, would you like to say anything about this issue?
Well, I think part of it is a personal safety issue. Some of the other tenants have come into this meeting and threatened the other tenants with violence. So I just think that we need some type of basic standard in that we can, one, we can be safe there, and then two, they've talked about several things. They've talked about budget. They've talked about all types of things. They got this new proprietary budget thing going.
I'm sorry, I don't want to interrupt you, but just because we still are sticking to the issue of jurisdiction, of whether we can hear this case, so it's not about the content so much as the issue that can we hear this case from community housing program. And so in the case before, when we were laying out the reasons we couldn't, those same issues apply. So if there's something different that you can see, we haven't even gotten to the issue of content. It's definitely the issue of whether we can even hear this. So is it in our realm?
I think of it more as in, they're receiving over $250,000 a year, and she hasn't brought any evidence to say that somehow this is a separate entity or anything like that, so that, but I also just think that there needs to be some type of better standard as to how these meetings are run, because they're saying like children can't speak in these meetings. They're saying if you come 15 minutes late, you can't attend.
Once again, sir, sorry, the rules and all that stuff right now, it's just not applicable for this portion of us hearing this. So if you don't have anything else to say about the jurisdiction of why you think we should.
The jurisdiction is it's $250,000, and more. And I definitely believe that's why they have jurisdiction. I mean, so the merits of the case are not really relevant. It's more about community housing partnership and a citizen having a complaint. I don't think it has anything to do about the what this body is or what they do. It's just more about City of County of San Francisco. It's more about the Sunshine Ordinance and the Community Housing Partnership.
Okay, thank you. Do any of the task force members have any questions, comments, anything of that sort? You do get 3 minutes to respond to this if you have anything you want to say to conclude about jurisdiction.
Just in conclusion, not about jurisdiction, but I would just say that any requests that Mr. Pitts has in reference to addressing concerns of safety, we have a grievance process where we are working and will continue to respond, and any information in reference to the tenant council, I'm just stating we've provided documentation about the spending and all of the requests that he has made. I have copies. I'm more than willing to provide Mr. Pitts with additional copies of my letters, and so I'm just openly stating that we're more than happy to continue to try to identify his concerns and respond to them. So I just want to state that.
Thank you. Mr. Pitts?
She hasn't responded to all of my requests for information, and what I would say is have her send you the information and have her give that and then you give me that information. So I haven't got all of my information, like she says. And then the other thing too is like the court issues that I've had. They really turn their back on the citizens, and we try to ask them for information. We try to do all types of stuff. They more or less do like they feel like. Let me pull up one document.
Okay. Well, you have 3 minutes about jurisdiction. You can't pull up the documents now because that's so. If you have anything else to say about, in conclusion, about...
Well, she went off topic, and I'm trying to speak in regards to that.
Yeah.
And I'm just saying, like, she's not giving us information. She's not giving it to us on time.
Mm-hmm. Okay. Thank you. Is there any more public comment? Public comments closed. Is there a motion to find jurisdiction or not find jurisdiction? Member Nee.
I move to find no jurisdiction.
Do I have a second?
Second.
It's been moved and seconded. Public comment again? No.
Just ask.
Yeah. So at this moment, the matter is concluded. Thank you both for coming. Did we vote? Sorry.
Is there any objections?
Is there any objections to the motion, to passing this motion without objection? No? Then I move that the matter is concluded and that this motion is passed without objection. Thank you both for coming, and I hope you guys are able to work it out, and you guys can try to communicate with each other. So,
how do you work things out with people who have no respect for us? Flaming disrespectful of the citizens of the city and county of San Francisco.
Thank you. Okay. Madam Clerk, at this time, we have items 12 through 19, the approval of minutes. I'm hoping that we might be able to move those to the next meeting, but I do want to get to the administrator's report and the announcements. So I don't know if there's anyone that would move that we can.
Move to continue items 12 through 19 to the December meeting.
Thank you.
I'll second, but I do have edits for 2 sets that are almost complete, so this helps.
So we'll give that to Madam Clerk.
And if we could make those changes before next month, that would be
that'd be great. And then
fabulous.
move forward. Okay. So we'll give those to her.
Public comment?
And then, no one's here.
You have to state it for the record. You have to say it for the record.
No one's here. Any public comment?
No, you say
I mean,
there's
I'm
no
sorry,
one in the
no one is in the
And
gallery.
did we, without objection, approve the continuance of?
We moved and seconded. Second.
I seconded it, and
Is
with-
there any objection? And I'd like to move that we, without objection, we pass Member Nee's motion that we continue items 12 through 19 to the December meeting. Can you read item number 20? If there's anything you want to share with that.
Item number 20, Administrator's Report. The report is in front of you. If you want me to expand on it, I can.
Does anyone have any questions about it? Okay.
Yeah, actually, quick one. Was there like a big bump? Because for a while, we were all caught up, and then all of a sudden, is it like the pre-holiday sunshine bump? Why am I talking to the microphone? We're the only ones here. For the recording. Was there like
we were never
reason?
caught up. We just it
Yeah,
got worse.
if you look at the...
Oh, I looked at it.
The chart, you can see during one particular month, there were numerous complaints filed by one particular complainant. So that kind of put you back in the pipeline.
We were getting closer. We were like at 20.
We should assign everybody a ticket and you punch it. And when you have too many punches, you've used up all of your... No, I'm...
Really? So item number 21.
And I'm sorry,
Oh.
one other follow-up thing. Thank you for including the various bits and pieces of attachments here. That's actually helpful to me. The email list, is there a way to get the field with a date? Because we used to have a version that had the date of the communications, and this doesn't. Is there a way?
It might have dropped off, so that was not intentional.
Okay. That would be great in the future, so then we'll know which particular immediate disclosure request from. Thank you.
Great. So now is item number 21.
Item number 21, announcement, comments, questions, future agenda items.
I don't have any announcements.
I do have an announcement. This will be my last meeting.
No.
It's been a pleasure working.
What? No!
I'm going back to the legislative side to do more compliance and research, which
We
is
need
my
you.
background.
No, you can't leave.
This is my last meeting.
You're the best we've ever had.
Wait, are we allowed to vote? Are we allowed to vote on this?
It's being presented as a question. This is a.
You need to take you out of Mr. Warfield.
Wait, did you so why didn't you tell us last month so we could have had like roses and champagne and all that?
We're working out some things, but
What?
so Victor will take over.
You're never
starting
coming back?
tomorrow. I may be back to shadow Victor if he has questions, maybe at next month's meeting. But from this point on, after today, it'll be Victor will be your contact.
But we want you instead.
Thank you for.
Well, we
thank
just
you
want to
for
say
your work.
thank you.
Thank you.
Thank you for being so helpful and so
So
thorough.
will you be here to kind of shadow whatever our next meeting becomes? Well, it's for
That's
sure
what he just
December,
said.
so you
She
will
just
be
said
here.
that for a little bit.
No, you will be here.
She'll be in the clerk's office. She won't
Oh.
be too far away.
Okay,
You're not
great.
leaving the city. You're actually like swapping with Victor, so Victor will be the full-time
Wait, no, wait,
clerk administrator?
Wait, before you guys leave, wait.
I'm sorry, so who becomes the full-time?
Victor.
Victor.
Wait, does Victor become the full-time administrator clerk?
Yes.
Okay, so he won't be doing budget or RBOC anymore, just this. Okay.
Great.
I had a couple of quick things.
Okay.
Can we file a sunshine ordinance complaint that we want to keep you, or does that not? Would you have to then defend yourself and then come over here and it would? No. Okay.
What are your items, David?
Can we do that?
In response to actually Mr. Pitt's complaint and discussion that we had at EOT, I did attend a meeting of the local homeless coordinating board and view their conduct, and I met with the staff afterwards, and they are changing their procedures a little bit as a result to address public comment, training of board members, et cetera. What that really brings up, though, is that the training that we have in place is really all about decision-making, charter boards and commissions, and doesn't do a good job of training for advisory bodies, of which there are many in the city, and there are people that are appointed with individual specialties and others that don't, and so there's quite a variety of folks on advisory bodies, and we, I think, need to figure out how to better deal with that training issue there. I don't have a good answer for it, but it is very much an issue, and I wanted to raise that. Next quick thing, the Ethics Commission is considering on November 25th amendments to its regulations regarding Sunshine Ordinance declarations. It's not a big change. They would allow filing by fax or email. They also made some other changes, minor league changes to their manual for handling referrals from us. They're able to change their regulations, and I'm not contesting that. I do think it would be good if, Madam Chair, if you sent a letter, and I could prepare it if you want, encouraging them when they consider changes to their regulations that have anything to do with the Sunshine Ordinance to send them here so that we might consider them. We might or might not make comment on them, but at least as a matter of protocol, they should send them here because they have to do with sunshine, and so there you go. So I'd be happy to collaborate with you on such a letter. And finally, EOT will have to be rescheduled in November because of Veterans Day, and I will work with Victor, and we'll figure it out. But we will reschedule EOT to happen.
So should Victor be the one like we're talking about for the December meeting and all that kind of stuff? Okay.
And thank you very much.
Thank you. This meeting, please.
Motion to adjourn?
Without objection.
Second it. I think it's without objection. All. I will see you.
Good night.
We'll be seeing Andrea.
Thank you so much, Andrea.
Can't believe you're leaving us.
You'll be in the hall.
Did we work you too hard? Were we too difficult? Were we annoying?
Is there really?
Sometimes they meet, sometimes they just don't feel like it, and it's like,
Those are your image, right? You know, we are on the, my friend on the board commission is in Japan this week.
Leslie Katz.
Yes. They're in Japan on the port commission dime.
You're on the wrong commission.
She's like, oh, yeah, I can't go out with you for your birthday. I'm going to be in Japan with the port commission, and I don't have to pay a dime.
Now, what about Rebecca, her sister?
Hi, good to see you. You're welcome.
Now,
She's with Animal Control.
She is. She's the head of.
She's a director. Yeah.
But I've never been sure if she plays both sides.
She does. She goes back and forth. I'm not sure. She used to be with that undersheriff, Ellen something. She was, please, how many times I asked her out? The first time I asked her out, she said, I'm in law school. I can't handle anything right now.
Great working with you.
The first time I asked her out, she said,
Yeah.
I feel silly. The time I asked her out, she said, be serious. You're so... We actually met on a ski trip.
Thank you.
Good night.
Some guy at the time. With a girl or a...
Where are you going to?
I could text her and ask her.
I'm working on more of the legislative.
You know, so...
Yeah, that's cool.
Yeah, 4.5 years ago, I was dating another girl named
Is that you mean with...
Becca. Becca.
Is that you mean